Good morning, everyone. Can you see my slideshow?
Hey, good morning. I see I see the PowerPoint app. So the side panel
Yeah,
and the slides. Yeah,
Yes, good morning.
uh, let's try that. Okay, how about that?
there we go.
Okay,
Full screen slide only.
all right. Oops. Okay,
Yeah. Hey, Anthony, will you please make me a co-host?
Let's see. Yes, I can do that.
Great, thank you.
Mhm.
do we have to, we don't need to do it now, but before, as we get started, do we have to affirmatively turn on the recording?
Looks like it already is on.
Okay.
Yeah. Yeah. Well, I guess I can pause it until we actually get started because I see in Alex's
As
instructions
well, yeah.
to pause between the breaks and all that too. So I've gone ahead and resumed the recording. So that, yeah.
All right, we'll get started here in maybe a minute. Okay, my clock just ticked over to 8:30. So good morning, everyone. Welcome. My name's Randy Otto. I'll be leading this training with Anthony Perillo over the course of this Friday and next Friday. The focus of our training is conducting competence to stand trial examinations in New Mexico. I would describe this training as sort of um, uh, some very introductory and basic kinds of things. And for those of you with more experience, that might be sort of serve the purpose of review. We'll also be talking about some more advanced issues, including a detailed discussion of New Mexico law and New Mexico procedure as it guides the examiner when he or she is conducting a competence examination. So you might consider that a little more advanced, particularly if you're new to carrying out these evaluations in New Mexico. Before we get started in content, just an alert that we are recording this training. We encourage you to offer commentary either using the chat function or by way of unmuting. We've got scheduled times for discussion throughout this Friday and next Friday, but keep in mind that your comments, questions, and whether they're delivered by way of the chat or delivered by way of unmuting and joining in will be recorded. You must attend both sessions this Friday and next Friday in order to be eligible for credit, including continuing education units. We'll confirm your full attendance upon completion of the second day of training and email you the CE link at that time. Each day, both this Friday and next Friday, please make sure to sign in and sign out using the chat function. It can be something as simple as Randy Otto signing in as we sit here now, or at the end of the day, Randy Otto signing out. Here's some more information regarding continuing education. We'll also repost this next week towards the end of the program, but just rest assured that if you do hold a license, we'll be making available continuing education credits for a subset of licensed professionals, and you'll manage that and take care of those things at the end of next week's session, and then you'll receive your certificates. Neither I nor Anthony have any financial arrangement related to the content of this activity or program, and the views expressed in this presentation don't necessarily represent the views, policies, and positions of the University of New Mexico or the New Mexico Healthcare Authority. So you have that in mind. Everyone who completes this training, your names will be provided to the Healthcare Authority. And when you do get your training certificate, whether it's for continuing education or just more generally, please make sure that you hold on to that just in case at some point in the future there's a request for documenting attendance or something like that. A couple other things. Completing the workshop does not make people certified, right? So those who participate both this Friday and next Friday, they're not certified forensic examiners in the state of New Mexico or anything like that. That's because we're not making any effort to assess the competence or abilities of anyone who attends the training. And there's a number of things that are required, certainly, to carry out these evaluations that will get minimal, if any, attention during the course of this Friday and next Friday. So a couple reasons not to consider participation in this training as certifying you in any way. The reason I mention that is I've carried out similar kinds of training elsewhere and have seen people make reference to themselves as having been certified or certified forensic examiners as a result of completing that training. And I wouldn't want anyone to make that same mistake here. If you're looking for additional training around some of these related issues, here's just a variety of websites that you could consider taking a look at. Neither I nor Anthony have any general financial interest in any of these programs or agencies. However, I will acknowledge that some of these programs do offer training that I've completed for them. And I think it'd be obvious if you completed any training that I was responsible for on those sites, I would benefit financially from that. But I have no financial interest, nor does Anthony, in these sites generally. Full attendance is required for the certificate. As I said earlier, you must sign in and sign out at the beginning and end of both days. Please don't sign in late. Please don't sign out early. Please don't forget to sign in or sign out. We also be offering some random polls and questions to get you participating. We ask that you turn your cameras on unless there's a super good reason for not having your camera on, just because we think it makes for a better and more sort of collegial flow of things. So please be mindful of that. We ask that the name on your screen represents who you are. That's only a problem if maybe you have a computer you share with someone or you borrowed someone's computer. But if you do participate, that allows us to refer to you by name. Should you unmute and join the discussion throughout the course of today and next Friday. Otherwise, please make sure your microphone is muted. You can use the chat function to submit or respond to questions. And when I'm speaking, I think Anthony will be monitoring the chat. When he's speaking, I'll be monitoring the chat and making decisions as to, when to best present those questions or comments, but also rest assured that we have slides peppered throughout this week's and next week's program where we can open it up for discussion if you'd be more uncomfortable unmuting and speaking with your question or comment. Okay. All right. Goals and learning objectives. Learn about the many ways that forensic evaluation differs from working with people therapeutically and how that impacts what we do when we carry out those kinds of evaluations. Learn about state and local criminal justice and forensic mental health systems. Learn how expert witnesses and expert testimony are considered in New Mexico. Learn about both constitutional law and New Mexico law that shapes the evaluation of defendants when there's a question about their competence to stand trial or their competence to proceed. Talk about the clinical evaluation of defendants in New Mexico when there's concerns about their competence to stand trial or competence to proceed. Learn a little bit about the characteristics of defendants who are ultimately adjudicated incompetent to proceed. And then finally, learn some strategies for communicating data gathered and opinions formed when carrying out these evaluations, both by way of report writing and testifying. So there are goals for these 2 days together, this Friday and next Friday. Any questions about the logistics of today's and next Friday's program, or housekeeping matters, continuing education, what we're trying to do here, or anything like that? Okay, for those who don't know me, I'll just briefly introduce myself. My name's Randy Otto. I've been here in New Mexico for just a little over a year. I'm a professor in the Department of Psychiatry. I am chief of the forensic division within the psychiatry program here at UNM, and for about 35 years before I came here, I was a practicing forensic psychologist in Florida with affiliations at the University of South Florida and Nova Southeastern universities. I guess the only other thing I'd like to share is that throughout my 35-year career, in addition to working at universities, I always had a practice where I carried out primarily criminal forensic evaluations, including oftentimes evaluating various competencies of criminal defendants. And the only reason I share that is I think that sort of experience delivering forensic services gives me a better appreciation of the variety of challenges and issues that come to people conducting examinations. I think in my experience, too often people who spend a lot of time at universities talk about how things should work and how they do work, when in reality they don't have a lot of experience in the system themselves. And I'll let Anthony introduce himself a little later today when he takes over from me. I want to start with some overview of things. As I make sense of this, I think that we can conceptualize three different ways that a mental health professional might be involved in legal proceedings, three different roles that he or she may have. One is as a treatment provider, you've treated someone who's now involved in some litigation, and you're invited, oftentimes by your patient herself, or your patient's attorney, to come in and talk a little bit about your treatment. And because apparently your treatment and your assessment of that person are in some way relevant to some legal dispute in which your patient is involved. I think very straightforward, typically. I will point out that I think when you get those invitations to testify about your patients, they're oftentimes looking to you for your expertise. They want to know things like diagnoses, and they want to know things like treatments and how effective the treatments have been. And that's really focusing on and looking to you for your expertise. The reason I mention that is because I think, in my experience, sometimes attorneys try to misrepresent this as, well, no, we're really not looking for expert opinions from this treatment provider. We're going to treat this treatment provider like a fact witness or a lay or ordinary or common witness. I think that's really a misrepresentation, and conceptually it's problematic. And I'll also point out that if the attorney can shape it this way, the attorney may be able to get the expert treatment provider into the courtroom at no cost to them, or very little cost to them, right? If you can convince everyone that this treatment provider is just like any other witness, they're not offering expert opinions about this person's emotional, behavioral, or cognitive functioning. All they're entitled to is whatever any other witness is entitled to, which might be free parking, and in Florida at least, payment of $7.99 for any costs that are endured. And I would very much encourage treatment providers, when they are called into these proceedings, to resist that, because I think it's going to be quite obvious quite quickly that they're looking for expert opinions, and they're looking on your expertise. But that's not what we're talking about in the 2 days of training. We're not talking about functioning in that capacity. Another role that a mental health professional can play, and other kinds of professionals too, is consultants, typically assisting counsel in a variety of ways, including things like identifying, examining, and cross-examining experts, helping lawyers understand issues, etc. I don't think it's a mental health professional who might function in a consultative capacity in this way, but other kinds of professionals, like maybe sociologists and social psychologists, who might consult on matters such as efforts to change the location of the trial, right? Maybe conducting shadow juries or mock juries to help attorneys sort of gauge their legal arguments, gauge how the trial is going. I don't think mental health professionals typically have special expertise in those kinds of pursuits, but that's a whole nother way in which a professional can be involved. And what I'll point out is that typically, when functioning in that role, the professional's typically not expected to offer any kind of testimony. And then finally, another role for the mental health professional might be as a forensic examiner, when they're called in specifically to examine someone, a litigant, almost always a litigant, because some aspect of their emotional, behavioral, or cognitive functioning is related to some psycholegal issue that's in dispute. What we'll be talking about over the course of the next 2 days is when there's some question about whether some aspect of a person's emotional, behavioral, or cognitive functioning affects their understanding of and ability to participate in the legal process. But of course, I think everyone in this training knows that there's many other legal issues that can be in dispute where the services of mental health professional might be sought. Other kinds of criminal disputes where there's disagreements regarding a person's mental state at the time of the alleged offense, maybe a sanity matter, sentencing or disposition in the criminal realm, competence to understand and exercise one's constitutional right to avoid self-incrimination when there's some questions about a waiver of Fifth Amendment rights and an ensuing confession or presentation of incriminating information by a suspect who's been detained, and then a whole variety of civil matters, right? Personal injury, disability, guardianship, conservatorship, civil commitment, a variety of other kinds of issues. But our focus, of course, this Friday and next Friday is when there's a dispute regarding or some question as to the defendant's emotional, behavioral, and cognitive functioning as it relates to their ability to understand and participate in the legal process. In terms of understanding the forensic assessment process, 1986, Tom Grisso, a retired forensic psychologist who finished his career at the University of Massachusetts Medical Center. 1986, he wrote a book called Evaluating Competencies that I think still has some value to this day, although it's 40 years old. And one of the most valuable things he presented there and in the edited second edition of that book was his model for forensic mental health assessment. And this applies to the mental health professional, regardless of profession or discipline. I think it's a very interesting and elegant model because it applies to any kind of case where the mental health professional is being asked to evaluate someone for purposes of helping lawyers and judges who are trying to get some questions answered about the litigant, how one can be most helpful. And so what Grisso, the model Grisso proposed is here in front of you. And he said if a mental health professional is going to seek to be of assistance to counsel or the court in those cases where there is a question about a litigant's emotional, behavioral, or cognitive functioning as it relates to some legal issue and dispute, competence, criminal responsibility, personal injury, disability, conservatorship, child custody, whatever. First thing the mental health professional has to do is know the law. Well, if you're going to assess a defendant's competence to stand trial or criminal responsibility, what's the law of competence to stand trial in the state of New Mexico or Texas? And exactly what is it that the court is concerned? What is it that the court is concerned with? And along with that, learn the various sort of legal rules and procedures that would impact your evaluation of the individual. Then the second thing Grisso says is as you review that law, the law of competence to stand trial or criminal responsibility or custody of children in cases of disputed custody, learn what it is. How does the law define that? How does it conceptualize or operationalize competence to stand trial? And he says that with that, you should be able to identify some psychological constructs. That is some reason for involving you as a mental health professional. And I think that's a very good point, that if you get asked to participate in a particular matter, you familiarize yourself or you're familiar with the law regarding that matter, and you can identify any matters for which you have particular expertise or specialized knowledge, you might well ask yourself, well, what am I going to contribute? But I think that's going to be very uncommon. I think if you get invited by a lawyer or a court to evaluate someone involved in litigation, it's going to be pretty apparent how there's some reasonable connection between the person's emotional, behavioral, and cognitive functioning and this legal issue that's in dispute or being questioned. And then Grisso goes on to say, from that, you should be able to identify what he referred to as psycholegal capacities. All right. And then once you have that in hand, what you're left with is figuring out the best way of assessing those psycholegal capacities. And there's a combination of techniques and approaches you can employ. Clinical assessment techniques or forensic assessment techniques. What's the distinction? Clinical assessment techniques, you'll notice I don't have tests here, but rather clinical assessment techniques. Techniques, tests, or tools, assessment approaches that have been developed to facilitate assessment of clinical constructs. Clinical constructs. So clinical constructs can include things like level of depression, or if there's impairment in mood, quality of someone's thinking, intellectual functioning. All of those are clinical constructs, as distinguished from forensic assessment techniques or tools, which are techniques or tools specifically designed to facilitate assessment of a psycholegal capacity. So just to sort of tie up this distinction, examples of assessment techniques that could be considered clinical assessment techniques, and the most commonly employed is the clinical interview. Okay, that's a tool or technique, not a test, that is designed to facilitate your assessment of someone's clinical functioning and adjustment generally. Okay, mini mental state examination, that's designed to facilitate assessment of someone's cognitive functioning. That is relevant. That's a clinical construct. Measure of intelligence, measure of depression, measure of academic achievement. A tool designed to structure your assessment of someone's potential for violence, their risk for violence. These are all clinical matters that can be relevant to forming opinions about persons who are involved in litigation. Forensic assessment tools or techniques, these would be tools or techniques specifically designed to facilitate assessment of a psycholegal capacity. So, for example, the fitness interview test revised, developed by a bunch of Canadian authors to facilitate assessment of a criminal defendant's understanding of an ability to participate in the criminal justice process. The Rogers Criminal Responsibility Assessment Scales, a tool designed to facilitate assessment of someone's mental state at the time of the offense, as it gets to whether they should or shouldn't be held criminally responsible. So this is Grissow's approach to forensic assessment that he introduced 40 years ago. I think conceptually, it can be very helpful in terms of working your way through a particular case or a particular problem, particularly when you're new to the assessment. And we're going to sort of follow this approach in that once we get some basic stuff under our belts, we're going to make sure we have an understanding of the law of competence to stand trial generally and in New Mexico specifically. And then once we have that under our belts, I'm going to turn it over to Anthony, who's going to talk about the clinical assessment process itself. In terms of sources of authority when we're delivering forensic services, I typically put them into two categories. One is what I call legal authority, and the other is professional authority. And what I'm talking about here is sources that can impose obligations on the professional when they're carrying out the particular forensic task. So let's sort of talk about them sequentially. So when we're delivering forensic services, we talk about legal authority. That is, where may there be some direction or authority that can impose obligations on us when we're delivering the service? What might we consider? So I start with the most basic, that is any practice act. It's the law in the state in which you're practicing that imposes obligations on you. So if you're licensed as a psychologist, it's the Psychology Practice Act in the state of New Mexico. If you're licensed as a physician, it's the Medical Practice Act. If you're licensed as a counselor, it's the relevant Counseling Practice Act in the jurisdiction in which you're delivering the service. No one would claim, for example, that if they're delivering forensic services as a licensed physician, that the Medical Practice Act doesn't apply to them when they're providing those services, right? No one would claim, I don't think, that if they're a licensed psychologist conducting a forensic evaluation, that the Psychology Practice Act doesn't apply to their work, right? Applies to any kind of service you deliver in your role as a medical, psychology, counseling, social work professional, whatever it is. Okay. Next, the substantive law that's relevant to the forensic service that's being delivered. If you're evaluating a criminal defendant's understanding of an ability to participate in the criminal process, you're hard pressed to say that the law of New Mexico that shapes what is competence to stand trial in this state and what's expected of examiners, you're hard pressed to say that that doesn't apply and impose obligations on you, right? And that'll become very apparent later today. So the substantive law of the particular activity in which you're forensic activity in which you're involved is going to be applicable. And those of you with any experience carrying out these evaluations in New Mexico know that there's a fair amount of law and rules, statute and rules in New Mexico that impose obligations on mental health professionals when they are carrying out these examinations. But there's other things as well. Rules of criminal procedure, at least when it comes to evaluating criminal defendants, these rules regulate how and when examinations are conducted, what's involved in the evaluation process, what needs to be in reports, when reports need to be provided, all kinds of things. And then finally, rules of evidence. Rules of evidence apply in all legal proceedings, and they govern what kind of information can be presented to the legal decision maker and how that information is presented. So I would make the argument that for a mental health professional, no matter what kind of forensic examination she's carrying out, needs to be familiar with all these areas and how they impose obligations on him and her. Now, the good news is, in most cases, there's no conflict between these various legal authorities. Sometimes there is. We'll talk about that a little later this morning. Typically, they're consistent, and it's easier than you might think, sort of gaining an understanding of how these sources of authority impose obligations on all of us. What about the alternative to legal sources of authority, what I would call clinical and professional authority? And I would break that up into two general categories. One is general practice authority. How does one go about assessing a defendant's understanding of and ability to participate in the legal process? For the longest time, all of this was determined by consensus, was determined by just general consensus. And how might that be accessed? By referencing authoritative publications that were considered authoritative by different persons or different populations. What we've seen develop more recently, and when I say more recently, I would say over the past 30 years or so, is the concept of practice guidelines. These are typically guidelines that are not issued by persons, but rather by organizations. Okay. And in that way, they have some level of authority. And as example of relevant practice guidelines, I would say, you might look to the specialty guidelines for forensic psychology that were first published in 1987. Were a second edition of them, a revised version of them came out in 2013. And then they're currently undergoing revision as we speak. That's for psychologists, of course. I think you're hard pressed to argue that the specialty guidelines for forensic psychology apply to anyone other than psychologists. There's other practice guidelines. The American Academy of Psychiatry and Law, for example, has general practice guidelines, forensic practice guidelines that they published. They also published guidelines specific to evaluating criminal defendants' competence to stand trial. Now, I would say you're hard pressed to argue that practice guidelines promulgated by a group of forensic psychiatrists, an organization of forensic psychiatrists, you're hard pressed to argue that non-psychiatrists can be held to those guidelines. That being said, I think it's probably a good idea to familiarize yourselves with those guidelines if you're carrying out these evaluations. Right? Why not? Why not know what a bunch of informed forensic psychiatrists had to say about how these evaluations should be conducted? I would argue that if you're a psychiatrist or a psychologist or a licensed counselor who's carrying out these examinations, there's more similarities than differences in terms of what you're doing here. So why not take the time to learn what some well-informed psychiatrists had to say about carrying out these examinations. On the other hand, if you are a psychiatrist, I think it's going to be pretty embarrassing, at a minimum, if you're not familiar with the competence to stand trial evaluation guidelines that were promulgated by the most influential organization of forensic psychiatrists. At a minimum, you would want to be familiar with them. I don't think you could be obligated to practice in a way that's consistent with them, but you'd want to be able to explain, I think, why you're not practicing in a way that's consistent with them if you aren't. And then what might be considered authoritative publications. And then obviously, I think the ethics code that's applicable to your particular profession or discipline can be identified as a source of professional authority. Indeed, many licensing boards, if there is a question about a professional's practice that is raised by way of a complaint to a licensing board, many licensing boards, if there's not specific reference to an ethics code in the licensing code, the licensing law, the Professional Practice Act, they'll nonetheless refer to, and maybe in some cases rely on, that profession's or that discipline's ethics code. And of course, those ethics codes vary as a function of your particular profession or discipline. So what I would say then, right, is when we're trying to figure out, we're thinking about what the forensic examiner is obligated to do when engaged in a particular forensic pursuit, I think it's going to be both some legal authorities that we want to be familiar with, and then also some professional authorities that we want to be familiar with. Okay. That being said, we're going to spend some time distinguishing between therapeutic and forensic pursuits and associated responsibilities. And I think when we get through this section, then we can sort of take comments or respond to questions. So I want to sort of lay out where we are right now with this. So I have a table that I put together here, and I'll sort of walk through this table. I'll point out that in the ensuing slides, much of what I say is laid out in succession. So I'll sort of spend a lot of time on this table trying to make my points. Then I assume everyone has a copy of this slide file. The next few slides really sort of sum up what I'm saying. So we'll skip through a few of them and then go to a couple slides and finish up our discussion. So distinguishing our working with people therapeutically from when we're working with them in some kind of forensic role or have some kind of forensic responsibility. I have long advocated that we think about, well, who is the client? Whose interests are paramount? I would say when we're working with someone therapeutically, I'm going to call that person the patient. When we're working with someone therapeutically, you might call them the client. Doesn't really make much. I don't think it makes much of a difference in term conceptually. But when we're thinking about, who are we primarily concerned with, I would say when we're working with someone therapeutically, it's our patient. When we're evaluating purposes who are involved in litigation, I don't think the person we're examining should be considered our client or patient. Rather, I think it should be the attorney who hired us or the court who appointed us. That's who our client is. Now, that being said, that doesn't mean that the forensic examiner doesn't owe duties to the person that he or she is examining, right? We have a duty of competence. We have a duty of respect when we interact with the person we're examining. We have to be, there's some duties of privacy. I think that obligation's a little different than when we're providing therapeutic service. But simply because the people we're examining aren't conceptualized as our clients or our patients doesn't mean we owe them duties. But my concern is if the people that we are examining, if we refer to them as our clients or patients, it sort of communicates a whole host of obligations that don't apply in this case, right? When we are working with people therapeutically, there's all these obligations that apply that don't apply when we're carrying out forensic evaluations. But again, that's not to say that we don't owe them any duties, the people we examine in the forensic context, but we just owe them different duties. So I never want someone I'm examining to think that they're my patient because it suggests all kinds of things that don't apply in the forensic examination context, right? It suggests that my primary goal is to sort of help them and their interests are paramount. And I'm working with them to facilitate their adjustment or something like that when that's really not my responsibility if I'm working with them in this forensic assessment context. So I'll call them anything but a patient. I'll call them anything but a client. I'll call them a defendant, a litigant, an examinee. But I really want to communicate that to the person I'm examining. When we're working with people therapeutically, when we're evaluating them, when we're treating them, the focus can be very broad, right? It can be whatever the treatment provider and the patient or client want it to be. It can be, communicating better with their spouse, working more effectively with their boss, being a better parent, managing their mood, becoming more assertive, whatever, getting a handle on their alcohol use. It could be whatever the treatment provider and the patient client want it to be. The focus of most forensic evaluations are pretty narrow, and they're oftentimes defined by the law. And there's a whole bunch of things we're not concerned with. There's a bunch of things that we don't investigate or consider. Confidentiality, there's standard confidentiality when we're providing therapeutic services to patients. In fact, they're instructed that most of what they tell us is confidential and private. It won't be revealed to anyone else. There's always exceptions to confidentiality, of course, but the general presumption is whatever we talk about is confidential. I never want someone I'm examining in a forensic context to think that anything we talk about is confidential. At a minimum, right? I'm sharing this information with the attorney who hired me, or the judge and other attorneys, the judge who appointed me and other attorneys who are involved in that person's case. Again, I want to make the point that because I have here that there's no confidentiality, that doesn't give me permission to gossip about their case with my spouse. That doesn't give me permission to talk about their case in this training unless I do it in a way such that they're not identifiable. But the idea that I owe them this general obligation of confidentiality that would apply if I was working with them therapeutically, that's just not the case. And as I said earlier, if I refer to them as my patient or my client, my concern is that in their minds that's accompanied by a whole bunch of obligations that they typically expect when they're interacting with a mental health professional. Privilege. Most jurisdictions have a psychotherapist patient privilege as distinguished from confidentiality. New Mexico does have a psychotherapist patient privilege. So not only what patients tell their treating mental health professionals in New Mexico, not only is it confidential, meaning that the mental health professional has a legal and ethical obligation to keep what the patient shares confidential, with some exceptions. Not only is it confidential, but it's privileged. That is, that information can't be revealed in a legal proceeding without the consent of or over the objection of the patient. Of course, there's exceptions there as well. Psychotherapist patient privilege clearly does not apply in a forensic assessment context because, well, number one, there's no psychotherapy going on. And the professional himself, herself, is not functioning in a psychotherapist role. Interestingly, in some cases, attorney-client privilege can apply, right? If the mental health professional is retained by defense counsel that represents the criminal defendant, then the examining mental health professional and her work can fall under the attorney-client privilege, likely with some exceptions, but there is a privilege that applies, interestingly, but it's not the psychotherapist patient privilege in the forensic assessment context. When we think about, right, think about working with people therapeutically, there's this, right, therapeutic alliance. Right, the general presumption is that there has to be some alliance between the therapist and the patient for maximal improvement, for maximal efficacy of the therapeutic relationship. Some therapists might see themselves as advocating for and advocates for their patients. At a minimum, I think therapists will describe themselves as aligned with and putting the interest of their patient primary. But I think the stance of the professional in a forensic context is considerably more neutral or detached, right? The last thing I want is a criminal defendant I'm examining for the court to think I'm pulling for them or I want good things to happen for them. I'm not I'm not pulling for bad things to happen to them. I'm not rooting against them, but I don't want them to think I'm their advocate. I don't want them to think I want their desires in this case to carry out. I want them to know that I may form opinions about them that they're not happy with, that they might see as going against their interests. If I'm examining a defendant's, when the question is his competence to stand trial, I want him to understand, let's say he is hoping he's adjudicated incompetent. I want him to understand that I don't have any investment in him being adjudicated incompetent, nor do I have an investment in him being adjudicated competent, by the way. My investment is in assessing him to the best of my ability so that I can best describe his functioning to the prosecutor, the defense attorney, and the judge. That's what my investment in it is, not in a particular adjudication, competent or incompetent, and not in a particular outcome for him or her. I want them to know that I'm not aligned with them. I'm not their advocate. And again, if I refer to them as my client, if I refer to them as my patient, I think that may mistakenly mislead them in that they might bring a whole bunch of assumptions that people hold about mental health professionals when they're working with people therapeutically. When we're working with people therapeutically, clearly the overwhelming volume of what we know about the patient is gathered from the patient himself or herself. Now, I acknowledge that sometimes when we're working therapeutically with children, we seek information from parents or school teachers, as an example. When we're working with adults, sometimes we might seek information from other treating professionals. We might seek information from spouses, as an example. But when you think about it, in most cases, when we're working with people therapeutically, the large majority of information we get from the patient himself or herself. I think that stands in meaningful contrast to our information sources when we're conducting forensic examinations, right? Much more diverse in terms of where we look to for information. And I think there's a variety of reasons for that, among other things, including what we believe the person's approach to the interaction may be. When we're working with people therapeutically, in most cases, they're there voluntarily. I acknowledge sometimes people come into our therapist offices because they've been given an ultimatum by their boss. They've been given an ultimatum by their spouse. I acknowledge that. Sometimes they've even been given an ultimatum from the court, right? The judge has ordered them into substance abuse treatment in lieu of maybe some kind of placement in an institution, a jail for some period of time, or prison. But in many cases, people who are seeking treatment are seeking so voluntarily. I don't think people seek forensic examinations voluntarily, right? I've been doing this for 35 years. I've never really had anyone come into my office. Dr. Otto, I think it'd be a good idea if I underwent a forensic psychological evaluation, right? Everyone that I evaluate is there because the judge said I had to get evaluated. My lawyer wants me evaluated. My disability insurer requires that I get evaluated if I expect to continue to get my disability payments. My spouse and I are arguing about where our children should live when this divorce gets finalized, and the judge has ordered us to participate in this evaluation. And I think in many forensic evaluation contexts, many, not all, the person we're examining may have an investment in a particular outcome. I want my kids to live with me and visit with my ex-spouse rather than living primarily with my ex-spouse and visiting with me on the weekends. Or I hope I'm found not guilty by reason of insanity, as distinguished from being considered sane and held accountable and responsible for these alleged criminal acts. And I think if that is the case, if the person has an investment in a particular outcome, they may adopt a response style that is something less than candid or straightforward. Okay. They may exaggerate and fabricate some impairments. They may deny and minimize other impairments. If I'm a divorcing dad who wants the kids to live primarily with him and visit my soon-to-be ex-spouse, I think I'm going to deny and minimize my problem drinking. I'm going to deny and minimize my anger problems, and I might exaggerate and fabricate other aspects of my personality or approach to living. If I'm a criminal defendant who, is hoping to be adjudicated not guilty by reason of insanity, I may exaggerate and fabricate some symptoms I claim to have been experiencing at and around the time of the alleged offense, while denying and minimizing other symptoms. That's one of the reasons, for example, that we don't simply rely on what the people we're examining in forensic context. We don't limit our data sources to the people we're examining, but look to other sources of information as well. The utility of traditional testing, whether it's psychological or medical, pretty significant, I think, when we're working with people therapeutically. Insofar as testing can facilitate assessment and identification of issues, problems, symptoms, strengths, deficits. Testing might help us do things like come to diagnoses and come up with treatment strategies. Traditional testing in forensic assessment contexts is, I don't want to say it's without value, but I think it's more limited, particularly when we think we have a good handle based on maybe collateral data as to the person's emotional, behavioral, and cognitive functioning, maybe a variety of problems, symptoms, challenges have already been identified. But I don't want to throw out the baby with the bathwater and suggest that there's no role for testing in the evaluation process. The role of diagnosis when we're working with people therapeutically should be pretty significant, right? At least insofar as different problems call for different treatments, and different treatments may be appropriate for different conditions, for different diagnoses. Again, I don't want to throw out the baby with the bathwater. I don't want to suggest that diagnosis is irrelevant in the forensic evaluation context. And you notice here in the left-hand column, it's the role of specific diagnosis. But I would say the role of specific diagnosis or the value of specific diagnosis is a little more limited. If the court comes to the mental health professional trying to get a handle on the defendant's competence to stand trial, I don't know how much of a difference it will make if we determine that the person's impairment is best described by schizoaffective disorder versus schizophrenia, right? Most significant from the court's perspective is whatever it is, whatever those symptoms are that are leading you to either the schizoaffective disorder or the schizophrenia diagnosis, most important from the court's perspective is how are those symptoms impairing, if at all, the person's understanding of an ability to participate in the legal process. And then, ultimately, I think all of this sort of reflects that the goal of the interaction between the professional and the patient in a therapeutic context is the betterment of the patient, right? Improve functioning and adjustment in one or more venues. The ultimate goal of the forensic assessment or forensic evaluation is to give whoever referred the person for evaluation, give them a better understanding of the person's emotional, behavioral, cognitive functioning as it relates to this legal issue and dispute, whether it's criminal responsibility or criminal competence or where the children should live post-divorce or whatever that is. Now,
I'll come in with the we've had a couple of comments that I think when I get to some of the clinical stuff we'll bring up as people are having a conversation about attorney-client privilege and how that's been an obstacle in New Mexico examinations in terms of obtaining records from counsel, and that's something we will discuss later. But yes, we have another comment here that is also clinical but integral here, so I would throw it out to you. That somebody said, I'm always curious to hear how other examiners maintain a neutral stance without seeming robotic, like how to use effective clinical skills to understand an examinee without coming off therapeutic.
Yeah, that's a very good question and comment. There have been a handful of articles written on something to the effect of the role of empathy in forensic examination, and some have gone as far to say that it's inappropriate to demonstrate any empathy for someone who you're interviewing or evaluated in a forensic context. I would not ascribe to that. I think I can appreciate someone's difficulties, whether it's the severity and level of their depression or how their spouse's suicide affected them, or how the fact that they maybe killed their spouse affected them. I think I can do that and sort of appreciate them in that interaction without misleading them as to that my goal here is to help them feel better and sort of towards their betterment. I think that can be done. And I think that if we take explicit steps at the beginning of our interaction to make our role clear to the people we're examining, we can reduce the likelihood that a demonstrated empathy, perhaps, a demonstrated empathy misleads them. And we can also remind them, right? We can also actually take active steps to remind them of our roles and what we're trying to do. But this has been, I will point out, this has been the discussion of the topic of some discussion with both mental health professionals and attorneys weighing in on the issue. Anything else, Anthony?
That covers it.
Okay. That's okay. Now, I told you all that many of these slides here are pretty much sharing with you what I just discussed. So I do want to sort of zip through them and just take you to a couple slides that I will use to make some additional points. So the role of diagnosis is what I was talking about just a little while ago. And I have a couple quotes from the DSM-5. And I got to figure, I mean, if any publication is going to advocate for the value of diagnosis, it's going to be the Diagnostic and Statistical Manual of the of Mental Disorders, published by the American Psychiatric Association. So even the American Psychiatric Association acknowledges the limitations of diagnosis. Again, they're not throwing out the baby with the bathwater, but they do explicitly in their diagnostic manual acknowledged limitations of diagnosis. For example, this is a quote, "In most situations, the clinical diagnosis of a DSM-5 disorder is not sufficient to establish the existence for a legal purpose of a, quote, mental disorder, quote, mental disability, quote, mental disease or mental defect." And I don't know how that happened. And we see this. We consistently see how mental disorder can be defined or described one way by mental health professionals and mental health organizations, and in a very different way by legal authority like statute. So, for example, I don't know if this is actually specific. I don't know if this applies in New Mexico, but when it comes to the insanity defense, many jurisdictions define mental disorder that can form the basis for an insanity defense. Many jurisdictions take steps to limit it to conditions that would be included in the Diagnostic and Statistical Manual of Mental Disorder. So that wasn't a good way to say that. Let me take another shot. There's many conditions that are considered mental disorders by the American Psychiatric Association that don't qualify as mental disorders in jurisdictions for purposes of an insanity defense. That's so simply because the American Psychiatric Association or some other group considers a particular condition to be a mental disorder, that doesn't mean it's good for being a mental disorder when it comes to a particular legal issue. That's the point I'm trying to make. Here's some more language from the DSM-5. When DSM-5 categories, criteria, and textual descriptions are employed for forensic purposes, there's a risk that diagnostic information will be misused or misunderstood. These dangers arise because of the imperfect fit between the questions of ultimate concern to the law and the information contained in a clinical diagnosis. In most situations, the clinical diagnosis of a DSM-5 mental disorder does not imply the individual with such a condition meets legal criteria for the presence of a mental disorder or a specified legal standard. So this, I think, is important for us to keep in mind, that going back to Grissow's conceptualization of forensic assessment and how it should be carried out, we're going to start with the law. That includes a recognition that the law might consider mental disorder differently. It might define mental disorder differently than the American Psychiatric Association, the World Health Organization, if you're thinking about an ICD perspective, or any other professional organization. And that's one, among many things, that's one thing that the mental health professional should be alert to. All right. Happy to take any questions or comments here. Feel free to unmute as I've been talking for a while. Or Anthony, if we've had anything else posted, happy to respond to that. Otherwise, we'll go into this next content area. Anyone want to unmute for a question or a comment?
The only addendum in the chat, at least, is, after you talked about, expressing empathy during an examination, somebody added that they focus on humanity and validate the struggles.
Sure. Yeah, I would not be critical of that. I don't know if there would be other professionals who would be critical of that, but I don't see that as problematic. Anyone else want to weigh in on any of the issues we covered so far, either with a question or comment? Andrew, I think I saw you unmute.
Yeah, Randy. So, like, I really love that you kind of mentioned that there is all this research out there about empathy. Because I think before I started my postdoc, I was really familiar with that, and I was kind of maybe a bit too, f too familiar with that I came off robotic. And that was something that I kind of had to work on in my training, right? Is that there's a way in which our work is described in journals and literature, and then there's the way in which it's done. And I think that, you're kind of that, there's definitely a balance. There's an issue there that's being addressed, but then there's also a way in which you can perform, you do your practice in a way that's mitigated. And I think that you did a great job of explaining that and definitely brought me some comfort in how I'm doing it.
I think that, at a very minimum, we've got to establish rapport with these people, right? We have to be able to understand their experience. We have to be able to understand their perspectives, and there's a way to communicate that, without, I think, without leading them to believe that you are rooting for them and you're aligned with them and trying to make sure that whatever they want in this particular legal context plays out for them. Uh, and I think if we make a reasonable effort to do that at the start of our exposure and content, exposure and contact with someone, I think they have a potential they should be able to get that distinction, I think, in many cases, at least. Any other comments or questions about that or anything else we've covered so far?
I can add that I typically I've also challenged fellows to, when this has come up many times, particularly early on during fellowship, and challenging them to explore the purposes of empathy expression. Is it actually for the benefit of the examination? Is it for your immediate perceived benefit of the examinee who might be in distress, or is it for you? And your own discomfort. Sometimes we've had like, I don't want to feel like I am cold, and I want this person to know that I'm a good person, and I share this empathy, and just like really exploring what the tension in the room might be, and how much of it might be internal versus what any kind of distress that you're actually seeing from the person that could impact the examination.
Sure. All right.
I just wanted to add, I think I've seen also on the other end of the spectrum, some examiners like almost getting a little manipulative with defendants when they're trying to assess for malingering or symptom management. I personally find that to be more unethical than just showing someone respect and humanity during an examination.
Yeah. Yeah. That's an interesting point. I remember, Caroline, and I want to, I don't know whose titles are what, so I'm going to use first names, and please use my first name as we communicate. Many years ago, I was delivering a workshop in Florida, and there was a psychologist from Key West, and Key West is an interesting place. And we were talking about assessment of response style, and I think it was in the when we're evaluating competence stand trial. I think Anthony's going to talk a little bit about that tomorrow. And he said, well, he said, you know what I do? When I've got a question about whether someone's feigning significant impairment, this is what I do. He goes, and by the way, I work in Key West, and we get a whole bunch of, we get all these people who run away to Key West, and they're going to have it. They're running from something or running to something. He said, so, if I start, I'm in the jail, and I'm ordered by the judge to evaluate this guy, and I'm asking him his name. He doesn't know his name, and he doesn't know his date of birth, and he doesn't know how old he is, and he doesn't know where he grew up, I got the solution for that. And I said, oh yeah, so what's the solution for that? He goes, I just pull out my dictaphone. Now, some of you on the call are young enough that you don't know what that is, but that was sort of like the equivalent of a pocket recorder or something. And I just start dictating my evaluation. I go, I interviewed the defendant on July 16th at the Monroe County Jail. He correctly identified his name and date of birth and age. He reported he was born in Indianapolis and grew up the majority of his life there, and before relocating to Chicago, and has been in the Key West area for the past 2 months. I go, well, why are you doing that? He goes, that usually gets their attention. They're like, well, Doc, what are you doing? None of that's true. Why are you? He goes, well, and then I tell him, I go, well, look, no report, no pay. So I gotta dictate this report, whether you cooperate or not. So I think there's, and I think it's really hard to endorse something like that. I mean, that's a level of manipulativeness and coercion, I think, that most professionals would be uncomfortable with, not even to mention how it sort of represents the profession or the discipline. But it is, you can say that on one hand, and then you can think about some of these measures of response style where there is some level of missuggestion. One of the tools starts with, I'm going to ask you about a number of symptoms that are commonly encountered by people with mental illness, when in fact you're primarily discussing impairments that are not encountered by people with mental illness. That's sort of one of the whole premises of the test. So there can be some misrepresentation, and that's a little more subtle, but ask yourself, how do you manage that, and how do you respond? How do you respond to that? So it is a tightrope, for sure. In some of these contexts. I thought you were going to go, Caroline, when you began talking. I thought you were going to talk about a subset of cases where you see forensic examiners almost become champions for the people they've examined, right? They almost become champions. Just something as subtle as, and maybe this is my thing, I'd be curious to get people's responses to this, but how we refer to people that we examine. A rule I adopted many, many years ago was, if you're an adult, I'm going to refer to you as Mr. or Ms., and I'm going to introduce myself as Dr. Randy Otto, a psychologist here in town. And it's going to be Mr. and Ms. when I refer to you during the interview. It's going to be Mr. or Ms. when I write the report about you. But there are some high-profile cases where I've seen forensic examiners refer to the people they examine, the adults they examine, using their first name. Examples of that include, most of you can at least remember or know of the Jeffrey Dahmer case out of Milwaukee, I believe. Yeah, Milwaukee. He was accused of a string of heinous crimes: kidnapping, drugging, sexually assaulting, killing, and eating his victims. And he was pled not guilty by reason of insanity. He was examined by a cadre of mental health professionals, and at least one of the defense retained experts consistently referred to him as Jeffrey in her testimony, which I thought was problematic. It maybe, my opinion, it was problematic. I think it's unprofessional. I'm wondering if it was suggested by defense counsel. We need to humanize Jeffrey, Doc. So if you could refer to him by his first name, that would be good. The other high profile case, a little more recent case, was the Jodi Arias trial. She was a young woman in Arizona who was charged with the murder of her on again, off again boyfriend, and ultimately filed a defense claiming that she was a victim of interpersonal violence and acknowledging that she killed him, but that she feared for her safety. At least one of the defense retained experts referred to her as Jodi. Ms. Arias was in her mid to late 20s at the time. Jeffrey Dahmer, I believe, was in his late 20s or early 30s. And I had some difficulty with that level of familiarity. Yeah. Any other comments or questions before we get back to new content? No. Okay. Well, let's continue on now. Key components of a proper evaluation and report. Adequate and correct notification to the examinee. Making sure that they have an understanding of who you are, how you're involved in the case, how information you gather will be used, with whom you will share that information, and in what way, and how that may impact them at some later point in time. Adequate and correct notification to the examinee, and some attempt to ascertain their understanding. We'll talk, I think Anthony will talk about consent issues in more detail when he's talking about the clinical evaluation process. I always make an effort when I write my reports as well to share with the reader of the report what my notification process entailed, as well as my assessment of how much of that the examinee understood. Understanding and functional assessment of the proper psycholegal issues and criteria, parenthesis, and nothing more. Couple examples here. Many years ago, 30 years ago, maybe more, there was a very high profile trial in South Florida where a young man, his name was Ronnie Zamora, Zamora. He was I think he was 18 at the time of his arrest. He was accused of murdering his elderly neighbor and driving her car to Disney World, and was ultimately arrested and charged with a murder. He had a very flamboyant attorney by the name of Ellis Rubin, who lodged a television intoxication defense. Now you're thinking, I've never heard of that. Of course you've never heard of it, because he lodged it and it went nowhere. But his argument was that Ronnie Zamora, a big TV watcher, had come to not really understand what it meant to die, because he watched a lot of crime shows. We're talking in the 70s. We're talking shows like Beretta and Kojak, shows like that many of you probably have never even heard of. But he watched a variety of shows where television shows where people would be guest stars and they would get killed, but then he'd see them next week on another television show. Ronnie Zamora didn't really appreciate killing someone like the rest of us appreciate, in part because of his youth, as well as his relative youth, as well as his television dependency or in intoxication. And interestingly, what they did was I don't know how many experts they had, but they had hired a psychologist from a nearby university whose expertise was research examining the relationship between viewing violence on television and violent behavior. She was a social psychologist, and that was her area of study. And Rubin thought it would be good to get her to testify. And so she testified at trial. And the first question on cross-examination, the first question out of the prosecutor's mouth on cross-examination was Dr. Wilson, whoever it was. Dr. Wilson, do you know the definition of insanity in the state of Florida? Right? Well, she didn't, that was not what she was testifying about, right? She was testifying about the science or the research regarding the relationship between watching television, violence on television, children and others, and violent behavior. She had not examined the defendant, Ronnie Zamora, or anything like that, but focus on proper psycholegal issues and criteria. Another occasion, I remember I was testifying in the state of Texas in what was essentially a Daubert or Fry hearing in Texas. It was a sexually violent predator matter, civil commitment of people with a history of sexual offending. I had been hired by defense attorneys in the state of Texas to talk about some matters. So it was a Fry kind of Daubert hearing. The first question I got on cross-examination from the prosecutor was, Dr. Otto, can you identify one significant way that the sexually violent predator law of Texas is different from the sexually violent predator laws of almost every other jurisdiction? I had the answer, which was, if you're identified as a sexually violent predator in the state of Texas, you don't get civilly committed to an institution, but rather you're ordered to participate in outpatient treatment. That's a real meaningful difference. And then he went on, right? What he was doing was he wanted me to say no. No, I have no idea. I'm from Florida. I got hired to come in and testify in this case. And he's trying to make me look like a goof in front of the judge. It was a Fry Daubert hearing, so there's no jury in that matter. So understanding and assessment of the proper psycholegal issues and criteria and nothing more. I'll just give you one additional experience here. There was a case in Southwest Florida where a psychologist had been appointed by the court to evaluate a criminal defendant's competence to stand trial. Court appointed by the court, or appointed by the court. So the results of this competence evaluation go to everyone, the judge, the prosecutor, and the defense. This particular psychologist evaluated the defendant. The defendant was sort of borderline intellectual functioning, established. She was charged with lewd and lascivious conduct. Might not be a common charge in all jurisdictions. Basically, she was accused of fondling a minor child who had been left in her care. And the question, was she competent to proceed? The defense had hired an expert who opined she was incompetent. The prosecutor said, Judge, you appoint another expert. The court appointed this psychologist to examine the defendant and evaluated the defendant. She opined that the defendant was competent to proceed, but didn't address all of the factors that she had to address according to Florida law. She did not address 3 of the 6 factors an examiner is required to address. Opined that the defendant was competent to proceed in the state of Florida, competent to stand trial. She described the defendant as a psychopath and identified the defendant as in need of long-term incarceration in order to prevent continued sexual offending. The defense attorney, you could imagine, was a little upset with this examination that was incomplete in one level. The examiner didn't address all factors required by statute, and in other ways was excessive, right? Made a sentencing recommendation, offered a opinion regarding psychopathy without an adequate factual basis, I would say. I just think about it, right? I mean, recommended that the defendant be in prison because if she wasn't in prison, she would continue committing sex offenses. That's interesting, right? Because she's not even been convicted of the sex offense. But what did the defense attorney do in response? Filed a complaint with the Board of Psychology. The reason I know any of this is because the Board of Psychology hired me to review her case. And is this acceptable conduct when you're conducting a court-ordered competence examination? I think my description of all this reveals my opinion. So she was vulnerable to sanctions by the Board of Psychology based on my independent assessment. She was very fortunate in that she had a very good lawyer who was able to get the complaint dismissed on procedural grounds, not on substantive grounds, but on procedural grounds. So you can imagine, this idea that we do what we're appointed to do and we're familiar with it. I think is meaningful. I think good forensic evaluations are characterized by efforts to access and consider relevant collateral data, and whether that's records or talking to people who have some potentially valuable information relevant to the opinions we need to form. I think there's explicit consideration of response style and its impact on the examinee's presentation, because in any forensic examination context, it's quite possible that the person you're examining has a vested interest in a particular outcome. And I think at a minimum, we have to explicitly consider response style and how it might impact the examinee's presentation. Note that I'm not saying that we always formally assess response style, that we always administer tests that give us some insight into that. But I think at a minimum, explicit consideration. Assessment of the examinee's emotional, behavioral, and cognitive functioning, and linking any observed impairments to deficits in psycholegal capacities, particularly in the competence context. And then when it comes to testifying and writing reports, we use language, terms, and concepts that the audience understands. We make efforts to discomplicate complicated concepts by way of adopting the following strategies, right? Avoiding or explaining jargon. I would identify jargon hotspots to include medication names and functions, dosages, other kinds of treatments, diagnoses, I think, by definition, or jargon. I think where we write about behavioral observations or mental status or describe it verbally, they're jargon hotspots. If we talk about testing, I think typically you're likely to see a lot of jargon there. So avoiding or explaining jargon. After all, if we use words that the reader or the listener don't understand, how good a job are we doing of what we're asked to do, right? By definition, if we get involved in a matter, by definition, it should be because the matter involves complicated concepts with which the attorneys and judge are not familiar. And they seek our assistance in understanding mental disorder, all that goes along with that, as it might affect, in this context, understanding and participating in the legal process. If we're using words, if we're using terms, if we're using concepts that the people we're trying to help don't understand at the most basic level, we're not doing our job. We're not doing our job. Not only providing opinions, but opinions that are expert. We'll talk about that in a little while. Not only providing expert opinions, but providing the facts underlying the opinions. This is the opinion. These are the facts. Also providing the reasoning, providing not only data or facts that support our opinions, but data and facts that are contrary to our opinions. People might say, well, if you do that, you facilitate or you're providing data that can be used to facilitate cross-examination. And my response is, well, of course you are. And that's what you're trying to do, right? You want the limitations, you want the weaknesses of any opinion shared, right? You want everyone to know if this is a close call, that it is a close call. And while you came to an opinion, and these are the facts and reasoning that lead you to that opinion, there are inconsistent or contrary data and facts. But what we're trying to communicate is when you put all the data and facts together, including the data that support my opinions, contrary data that could be used to challenge my opinions, this is why I adopted the opinion I did. And I think that's consistent with the spirit of assisting the court. I'm not going to just put in the report the data that support my opinion. I'm not going to just testify about the data that support my opinion, but I'm also going to cite the other data and talk about why nonetheless I recommend adoption of my opinion and the reasoning involved. And then also making an effort to distinguish facts from inferences and opinions, so those distinctions are clear to the reader. I think that's really what we're trying to do, whether it's writing the report or testifying. Okay, so I think now we've got some time dedicated to any questions or discussion that we might have, and after we get through this, we'll take a 15-minute break. But anything come in, Anthony, by way of the chat that we should address before our break? And while you're looking at that, I'll encourage anyone who wants to unmute to unmute. Anything else, Anthony?
Nothing additional at this point.
Anyone want to unmute and offer a comment or offer a question about what we covered so far? Okay, seeing no comments, I have 5 after the hour. So I suggest that we each take a break, refresh our coffees, check our emails, and maybe reconvene at 20 minutes after the hour. Okay, certainly don't disconnect, stay online. See you in 15 minutes, 20 minutes after the hour.
Okay.
Okay, I have 20 minutes after the hour. So again, if anyone wants to unmute and offer a comment or question, give you a chance to do that. And if not, we'll keep moving with new content. Anyone want to comment or questions? All right, let's keep moving.
I have a quick question.
Oh, sure. Susan.
One of the things that Kuchar said when he reviewed some of the reports coming out of my office is that an incompetent defendant cannot give consent. Well, when you first talk to somebody, you don't know if you're gonna find them incompetent or not. So, but that's kind of a conundrum. So what do we do?
Well, I'm sure, well, I'll weigh in. I'll invite Anthony to weigh in. Couple points. One is, I know you're a psychologist by training, Susan. The ethics code says that informed consent need not be obtained in all cases. There's at least three major exceptions. One is if there's essentially, I'm paraphrasing, if there's other legal authority for conducting the evaluation without consent. So let's say you have a defendant who you believe is so impaired that he can't even understand the nature and purpose of the examination. The ethics code says you can evaluate him on the grounds that you've been ordered by the judge to carry out the evaluation. So there's one rationale. The second is that the APA ethics code makes an exception for evaluations where the purpose of the evaluation is to assess a person's decision-making abilities. And arguably, your competence evaluation is, at least in part, to assess decision-making abilities. So there's another sort of ethics exception for you there. The third thing there's two exceptions there you can get from the ethics code. I'll also point out that I think there's a general consensus in the field that all competence is not a monolith. So one could be competent to consent to an examination, but maybe not competent to stand trial or move forward with the legal process. Simply because you lack the capacity in one arena doesn't mean that you lack the capacity in another. So there's that. Now, what I would say is, I would say if we're going to recommend someone as incompetent, be adjudicated incompetent to stand trial, that up front in that report, we might say, I informed Mr. Jackson of the nature and purpose of the examination.
Right.
Despite my best efforts, it appeared that he lacked a meaningful understanding of the nature and purpose of the evaluation. However, I nonetheless moved forward because the evaluation had been ordered by the court, or the nature and purpose of the evaluation was indeed to assess decision-making ability. Maybe explain why, I think he was impaired, and not describe it as having obtained informed consent. Now, I don't know what Dr. Kuchar was saying. If he was saying, well,
Well, I'm asking because I didn't understand it either.
yeah, I mean, if his point is, well, Dr. Cave, you recommended to be adjudicated incompetent, so therefore you shouldn't have said he was competent to consent to the evaluation. You could do both, or you could evaluate him without the consent on one of two grounds, at least from an ethics code perspective. That's my response to your query, Susan.
The other thing he said is that we should not use the word consent. We should use the word assent, that he assented to participate in the evaluation.
I think people who can't consent can assent.
Okay.
You can't do both. If I'm going to suggest that someone does not have the ability to consent, I can say, but nonetheless, he assented, he agreed to move forward with the evaluation, which I was just fine with because, one, I had legal authority for carrying out the evaluation, the order of the court, or remember, you have that other exception in the ethics code. That's all in, I think it's section 3 of the ethics code where I think it's section 3, or it's really interesting, right? There's three sections of the APA ethics code where there's a discussion of informed consent, probably unnecessarily. One, there's a general section addressing informed consent. 2, there's informed consent in the assessment section. And 3, there's informed consent in the treatment section. So that discussion that I'm talking about, I think, is the discussion of informed consent in the assessment section, which might be section 9 or section 3. So I agree that if someone can't consent, they might be able to assent, which would be willing to go along. Yeah, I do agree with that.
Well, it seems to me that someone who's like psychotic and out of it, and we explain like we always do, you know, who we are, why we're here, what we're doing, who gets the report, etc. But they're psychotic, so they lack the ability for rational and factual thinking, which is the definition of competence. That then should use the word assent.
Sure.
But if it's the person is rational and we can talk to them, we can explain it, and they seem to understand, then that's consent rather than
I don't dispute that. Yeah.
So that's kind of how I look at it. My other question is ethnicity. As we have been told not to make reference to anyone's ethnicity, whether they were Anglo, Hispanic, Native American, citizen of a foreign country, etc. Obviously, we don't get anybody's legal status. That's none of my business in terms of immigration or whatever.
Yeah. This is a very interesting
we mention
issue.
Ethnicity.
And who told you that?
This Kuchar.
Dr. Kuchar said that.
Yes.
This is I think there's some I will post to the chat section some very interesting recent discussions of this issue. There's a couple good publications. One is Riggs, Romaine, and Kavanaugh. The other is Heilbrunn, Grisso, Kavanaugh, and others about ethnicity and race in the forensic evaluation context. I think that in those two references, which you can access when I'll provide you the sites, they come up with a good rationale for discussing it, but I'm going to just give you a shorthand. Discuss it when it's relevant. And when is it relevant? And in the publications themselves, they talk about when it may be relevant. And I think I like both of those pieces. So that's what they say. Dr. Kuchar says you never do it. I don't. Okay. He says never do it. I don't know his rationale. But I've adopted a position whereby I cite it when I believe it's relevant to understanding some aspect of someone's presentation and what you're seeing. But I will give you those references.
Okay, where I think it's particularly important is dealing with Native Americans. Okay, because I think their cultural, their educational experience, their personal experience can be quite different from people who, I would say, mainstream culture is what I would call it.
Yeah, I can imagine, and I can think of others for whom it is relevant. And again, I'll piece those references into the chat for sure. All right. Any other questions or comments?
Thank you.
Someone should mute. Someone needs to mute. There we go. Okay. Let's talk about some rules of evidence and implications for experts.
All right, Randy, there's a couple of comments in the chat more about the consent assent issue.
Go ahead, Anthony.
Yeah,
sure.
Yeah, and somebody notes, you can't really consent to something that's court ordered. There's no choice there, but you can assent. You can be agreeable, but the argument of do you actually have the options? And then somebody said, I typically just say they agreed to participate in the interview. More straightforward. Don't know whether a zealous attorney would grab onto assent for testimony purposes. I personally use agreed to, because at that point, like reference, I don't really know at the beginning their rational capacities or how voluntarily or rationally that part of consent would be. So I'm just describing at the beginning, I said these things and they agreed to participate with me.
Okay. I think that works too. All right. Let's talk about rules of evidence. At a basic level, New Mexico identifies or distinguishes between two kinds of witnesses. And these words are used interchangeably among people. Sometimes are referred to as lay witnesses, common witnesses, ordinary witnesses, fact witnesses. The titles, the concept's the same. That's the majority of witnesses, by the way, who testify. They're typically limited to testifying about facts. That is what they sensed, what they saw, heard, tasted, felt, or smelled. Sometimes, just sometimes, fact witnesses, I'll just use that term, are permitted to offer opinions to the extent that such is needed to understand their observations, providing these opinions are rationally based upon perception, helpful to determine an issue, and not based upon scientific, technical, or other specialized knowledge. And this is, remember, we're talking about fact witnesses offering opinions. So you might be thinking, well, how is this even possible or relevant? They can offer opinions, but they're not expert opinions, right? Because they're not expert witnesses. They're not qualified in that way. This allows, for example, a fact witness to say, my husband was drunk. That's an opinion. That's not a fact. Typically, fact witnesses, lay witnesses, are limited to testifying about what they sensed. Now, someone could say, my husband was staggering. Well, staggering's an opinion. What do you mean by staggering? He was moving from foot to foot, and it appeared as if he was close to falling. I smelled alcohol on his breath. His eyes appeared glassy. That's an opinion, right? So at some point, they may well allow the witness to say, my husband appeared drunk, or the defendant appeared drunk. Technically an opinion, but they might allow that. Or the car was speeding. That's an opinion, right? You could say the car was going faster than any other cars nearby, going in the same direction. That's a fact, or an asserted fact as a witness. But to say speeding, that's an opinion. They're probably going to allow that. The perpetrator was angry, right? Now they might, well, why do you say he was angry? Fact witness, he was yelling. His face was flush. So sometimes lay witnesses, fact witnesses get to offer opinions, but typically they're limited to what they heard, saw, tasted, smelled, or felt. Expert witnesses, in contrast, are expressly allowed to offer opinions and are expected to offer opinions. And you can see here I have in parentheses, they're expected to offer expert opinions, and we'll talk about why that's in there in a slide or two coming up here. But 701, Rule of Evidence 701, talks about lay witnesses, fact witnesses. So we have throughout the training some what we call case problems, which we've put in to get you to think about some of this. So I'm going to give you three options, and I encourage you to respond using the chat. Just real quickly, you've got three options. You can describe this as a statement as a fact, an opinion, or an expert opinion. She arrived, sorry. She arrived promptly for her 9 a.m. appointment. I apologize for the missing word. She arrived promptly for her 9 a.m. appointment. If you wrote that in a report, would that be a fact, an opinion, or an expert opinion? She arrived promptly for her 9 a.m. appointment. Just put in the chat what you think. Fact, opinion, or expert opinion. All right. Can you give us some indication of what we're seeing, Anthony? She
So
arrived.
far, two out of two are opinion.
Okay.
Yeah.
All right. I would say it's an opinion. In my opinion, you arrive promptly for a 9 a.m. appointment if you arrive at 9 a.m. or before. Based on my experience teaching undergraduates, I know that their opinions about what prompt means is not necessarily at the appointed start time of a session or class. That it seems that some people hold the opinion that arriving at 9:10 for a 9 o'clock class is prompt. But I would say I have an opinion about what prompt means, and other people might as well. I also point out that I have no expertise on determining what is prompt or not. I have no specialized knowledge or training in determining promptness. The defendant was appropriately dressed. Is that a fact, an opinion, or an expert opinion? What do you think? Fact, opinion, or expert opinion?
4 out of 4 say opinion so far.
I think it's an opinion. It's not a fact that again, if I change this to the student was appropriately dressed, it seems to me that some of my undergraduates think that it's appropriate to dress in pajamas for class. I'm not of that opinion. So we have differing opinions. We could write the defendant was wearing basketball shoes, khakis, and a t-shirt. That arguably would get us closer to facts. And certainly no one would ever assert that I, nor any other mental health professional, has expertise when it comes to fashion. So opinion, not expert opinion. How about this? I included a diagnosis of panic disorder on the form I submitted to the insurer. Fact, opinion, or expert opinion? I included a diagnosis of panic disorder on the form I submitted to the insurer. Little tricky. Anyone participating, Anthony?
Yeah, 4 out of 4 say fact.
It's a fact. I'm asserting that I included a diagnosis of panic disorder on the form I submitted. That I'm asking you to take that as a fact. I acknowledge I could be confused, I could be wrong, but I'm asserting that as something that occurred, a fact that I did that. The defendant meets diagnostic criteria for panic disorder. Fact, opinion, or expert opinion? The defendant meets diagnostic criteria for panic disorder. Fact, opinion, or expert opinion? We'll talk about this in a second here when we see how people are weighing in, but what are people saying, Anthony?
5 out of 5 saying expert opinion.
Yeah, assuming that the person who offered the diagnosis has specialized knowledge about diagnosis and mental disorder, including panic disorder, and they base that diagnose or that opinion on what the specialized knowledge they have. That is an expert opinion. Clearly, if your father, the auto mechanic, offers that opinion, then it's not an expert opinion. But yeah, we made the point. Everyone sort of got where I was going. The defendant was feigning psychotic spectrum symptoms during the forensic interview. The defendant was feigning psychotic spectrum symptoms during the interview. fact, opinion, or expert opinion? What are we getting, Anthony?
Now we've got 4 out of 4 saying expert opinion.
Expert opinion. Again, assuming the person who made the assertion has specialized knowledge about genuine symptoms of mental illness, exaggerated or fabricated symptoms of mental illness, and I'll point out, assuming they use that to form this opinion about the defendant, then it's an expert opinion. I will use as an example a case I had years ago where a psychologist offered that the defendant he was examining was not exaggerating or fabricating impairments because he looked him in the eye when he was sharing those impairments. He was saying, I hear voices that direct me to do this or whatever else. He based it on something based on eye contact during the communication. What I would say is that that is not specialized. This psychologist had it in his head that when people are looking you in the eye and asserting something, that means they're genuine in their presentation. Number one, I don't think that's specialized knowledge. Okay. Two, I don't think it's particularly accurate. It's not an accurate way to classify people in terms of genuineness of presentation as to whether they're looking you in the eye or not when they are asserting something or claiming something. So even though, this person had specialized training, I don't necessarily think that his reasoning was such, or his technique for assessing genuineness. I don't think his technique was accurate or scientifically based. But yeah, assuming that this opinion was based on specialized knowledge about ways to distinguish genuine from feigned symptoms, expert opinion. All right. So not every opinion an expert witness offers is an expert opinion. If an expert witness testifies or writes, the defendant arrived promptly for the evaluation, not an expert opinion, an opinion nonetheless. Expert opinion anchored in specialized knowledge, training, experience, and technique. So when can an expert witness testify? New Mexico Rule of Evidence 11702. Some of you with a little more experience will realize that New Mexico Rule of Evidence 11702 is very similar, if not identical, to Federal Rule of Evidence 702. And I'll just alert those of you who don't know that many jurisdictions, when it comes to their rules of evidence, they will sort of yoke them to the federal rules. So I guarantee you that if you go to Federal Rule of Evidence 702, you're going to find language that, if not identical to this, is very similar to this. And that's really handy. So, if you're in New Mexico, you want to know, well, what's the FRE equivalent? What's the New Mexico equivalent of FRE 702 or FRE 701 or 704? You can just go to New Mexico Rule of Evidence 11701, 702, 703, 704. So this is what it says about experts in New Mexico. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify in the form of an opinion if the expert's scientific, technical, or other specialized knowledge will help the trier of fact understand the evidence or determine a fact and issue. This is what I was suggesting earlier. This is the only reason you got invited, because there's a complicated issue and they're thinking that you, as a function of your scientific, technical, or other specialized knowledge, you'll be able to help them understand this complicated issues that involves questions of mental illness or intellectual disability or other developmental disability or whatever else. So if number one, you can claim, yeah, I've got specialized knowledge, okay? Two, there's sufficient facts or data that I have available to me. Either I gathered those facts or they've been provided to me. Three, I used reliable, i.e. valid, principles and methods in this particular case to make sense of or gather the facts or data, and I applied these principles and methods in this case, then I get to testify about and offer an opinion that because it's based on specialized knowledge that I hold, that the others don't, the attorneys and the judge, there's an adequate database. I used reliable principles, methods, assessment approaches, and I've applied those methods to the facts of this case, then yes, I get to offer an expert opinion about the person's condition, as an example, their diagnosis, their condition, as it affects maybe their ability to understand the legal proceedings or whatever else. Real quick heads up, oftentimes when the law uses reliable, it's really implying validity. They're not talking about I think many times when you see the word reliable, it's probably makes sense to sort of swap out the word valid principles and methods. Do they want the methods to be reliable in terms of how mental health professionals think about reliable? Yes, they do. But reliability is only one piece of validity. So we get to testify and offer opinions about things for which we have knowledge, skill, experience, training, or education, if that will help the trier of fact. I would suggest that we always try to limit our opinions to expert opinions. It's not going to keep me up at night if you write or you testify that the defendant arrived promptly. But just recognize that there is a real important distinction between expert opinions and non-expert opinions. So what I would say is that if you go back to 702, 11702, our primary job is to help the trier of fact understand the evidence or determine a fact and issue. And if we don't write about what we do, if we don't testify about what we do and did in ways they understand, using words they understand, concepts they understand, then we're not doing our job. That's my point about how we should communicate what we did, keeping in mind the audience. What I tell judges and attorneys when I train them is this, that if you ever get a report from an expert, it doesn't matter if it's a DNA expert or a mental health professional who's serving as an expert, a ballistics expert, a forensic accounting expert. If you get a report or hear testimony that you don't understand and you were paying attention, the expert's not doing her job. She is not helping you, the trier of fact, the jury or the judge, and the attorneys too, understand the evidence or determine a fact and issue, because they're not using concepts, terms, language, or words that the recipient, the listener or the reader, is understanding. All right. Okay, so we know what an expert witness is. We know when they're permitted to testify, what makes an expert witness. You can probably boil it down to what I and others have referred to as the 3 E's, education and training. I'll start by saying rarely is there statutory reference to who or what is an expert. You can find some some exceptions to the general rule, but rarely does a statute say that in order to be qualified as an expert in this field, you must have this degree or this training or this experience. Sometimes you will see that. And here's an example, right? New Mexico statutes and rules surrounding competence talk about psychologists, physicians, and other qualified professionals conducting competence examinations. So other qualified professionals means it's not simply limited to psychologists and physicians, but it's a more general or vague term that could be inclusive. Now, on the other hand, the state agency contract requires that it be limited to psychologists or physicians or those who are supervised by psychologists or physicians. That's different from the court's decision-making. Courts usually allow psychiatrists and psychologists to offer opinion testimony around mental health matters. Whether other healthcare professionals are qualified may depend on the court, the jurisdiction, or the issue. As an example of a statute where testimony may be very expertise or the expert may be defined very specifically. I'll give you two examples from the state of Florida, where I spent 35 years. According to Florida statutes, if there's a question about a defendant's competence to be executed, there's a question about a defendant's competence to be executed, the defendant is to be examined by a panel of 3 psychiatrists, very disciplined, profession focused. The panel cannot include other kinds of mental health professionals, limited to psychiatrists, not just limited to physicians, limited to psychiatrists. Another example is in Florida. If someone who's the subject of a guardianship has had a guardian appointed, the court can consider removing the guardianship based upon examination by a physician, not other healthcare professional, but they must be licensed to practice medicine in the state of Florida. But those, I think, are more exceptions to the general rule where there's some flexibility offered. Also note that in addition to maybe training in the substantive area, mental health matters, for example, the court could consider other aspects of education, including, forensic training or training like this. The second E is experience. Experience can, in some cases, trump title. A great example of that is a very old decision, Jenkins versus the United States. This was a case, a sanity case. And what had happened, this is in the early 1960s, right? The defense had hired a couple psychologists to evaluate the defendant who was pleading not guilty by reason of insanity. Hired a couple psychologists to evaluate the defendant who was pleading not guilty by reason of insanity. The prosecutor or the court had appointed a psychiatrist or two to examine the defendant. The psychologist testified, the psychiatrist testified. Before the jury, after the testimony was offered, the judge directed the jury to ignore the opinions and testimony of the psychologist on the grounds that they weren't physicians and weren't qualified to offer opinions about mental disorder and as it might be relevant to informing opinions about culpability or criminal responsibility. The defendant was convicted. The defendant appealed, And the appeal was in part on the grounds that the judge wrongly directed the jurors to disregard the testimony of the psychologist. The argument was that they were qualified as a function of training and experience to weigh in with those kinds of opinions, and the conviction was overturned. The last E might be evaluation procedure. And that's what a lot of what this 2-day training will be about, at least once we get through the laws and the rules that shape the evaluation process. In my experience, I think too often attorneys and the courts don't inquire about these matters when a mental health professional comes to testify, but rather what they focus on is the potential witnesses' education and experience. What kinds of degrees did you earn? What kind of licenses do you hold as a result? How long have you been doing this? How many times have you done this? In my experience, rarely do the attorneys and or the court consider the evaluation approach that the expert employed to determine if that evaluation procedure is, to use the law's language, a reliable one and a valid one. They seem disproportionately to focus on the experience and the education of the proffered witnesses, and I think that's an error. I really don't care how many times someone's done this kind of evaluation. I don't care where they went to school, where they did their internship. But if the evaluation procedure they're employing is not to use the law's word, a reliable one, a valid one, I'm not really interested in their opinions, because I don't know that they gathered the information, gathered the data they need to form the opinions that they're going to form. This was made alarmingly clear to me early on in my career. I was invited by a psychologist who had a very successful practice in South Florida. He said, I know you're at the University of South Florida. You do a lot of work and training on psychologists and other mental health professionals in the court system. Next time in your Miami, I'd like to take you out to dinner and talk a little bit about some issues. I said, sure. So picked me up and we went to a nice restaurant, and another psychologist was sort of complaining about the work of psychologists in the court system. And one of the things he said was, Randy, one of my concerns is that I think psychologists over-test. They do way too much testing, and a lot of times it's not necessary. And I said, I sort of resonate with that. And then what he said next really, really surprised me. And I will point out that this psychologist had pretty much devoted his forensic pursuits to matters of disputed custody. So he spent a lot of time and had a lot of work evaluating moms and dads and their children in cases where custody was disputed and the court was looking for some insights and guidance about parenting abilities and parent-child interactions and all the things that are presumably relevant to informing decisions about where children live and who gets to make decisions about them when parents divorce and can't agree to that themselves. That's sort of where he made his name, and he had a very successful practice doing a lot of this work. So he got to the point about, again, I think both of us being psychologists, he shared one of his concerns with psychologists were too test intensive, and too likely to use irrelevant tests. I sort of, again, resonated with that. But then what he said next really surprised me. He said, when in reality, there's only one test you ever need to use, in the context of a case of disputed custody. And that's where I was really thrown. And I'm sitting there thinking, well, what is the one test that could be helpful in any and all matters of disputed custody when mom and dad are divorcing, or maybe they were never married, they're separating, going their separate ways and arguing about what would be best for the children. Does anyone want to take a stab at what he hit me with next? And what is that test that he offered to me? Anyone biting, Anthony?
Not in the chat, no.
Not in the chat. I'll say this was about early 1990s, if that makes a difference. But I have to tell you, I was at a loss for words when he told me that the only test you ever needed to use in matters of disputed custody was the Bender Gestalt visual motor test. I was just shocked. And he went on to tell me that there's for those of you who aren't familiar with the tool, it's a less than 10, maybe 10 cards. Correct me if I'm wrong, maybe 10 cards that I'll say include representation of geographic shapes or designs or drawings. I'm happy to let someone else take a stab at explaining the stimuli. But you just have to see the card and, to the best of your ability, recreate the drawing or the geometric design. He went on to talk about how there's a card where you can get insight into the nature of the relationship between the child and the parent. He told me that there was a card that reflected the level of the drawer's psychopathy, or whether the person was high in psychopathic traits and characteristics. I was just shocked by that. My first thought is, did I miss the class where all of this was covered? Was I sick that day? Or is very disturbing to me. And what I know is that this man made a very good living interviewing and testing children and moms and dads, and forming expert opinions about parent-child's interactions and a parent's ability to parent, and whether a parent's parenting ability was limited by psychopathic tendencies based on how they recreated these various geometric shapes. And how does that happen, right? That happens because the inquiry, when the expert shows up in the courtroom to testify, is based solely on, well, where'd you get your doctoral degree, and where'd you do your internship, and if you did a fellowship, where did you do that, and how many families have you evaluated when the parents have been dissolving their relationship and arguing about what would be best for the children. I did it a lot, and I have, I've gone to well-respected institutions, but there's no meaningful inquiry as to the reliability, that is, the validity of the experts, the validity of the expert's assessment technique. I think that is a real challenge, and whenever I get my time with attorneys and judges, I try to impress upon them the need to sort of obligate the expert not only to talk about his or her training and experience, right, but also to talk about the evaluation procedure they employed and the justification for it, and that is indeed a reliable or valid approach, or a valid way to get the kind of data that needs to be gotten in order to form the opinions that the court is most concerned with. Any chat comments, Anthony? Or
No, somebody asked for a reminder of the test, and that was that you were mentioning, and that was put in the chat.
Yeah. Okay. All right. Okay. Now, what if someone wants to make that exact claim? That sure, you've got a great degree, you've got great training, and all the institutions where you learned what you know are respected and all of that. What if they want to acknowledge, oh, you've done this a lot, right? You've done this a lot, but we've got concerns about the technique you employ. Okay, that is permitted. Either party in a criminal proceeding, the defense or the prosecution, can challenge the techniques that the expert employed and the underlying science. I'll say this, those challenges are rare. Those challenges are rare for a number of reasons. If, for example, both parties' experts use similar approaches, it's unlikely there's going to be a challenge, right? Sure, you're the defense attorney, you can challenge the expert technique that another expert employed. You don't like his opinion, but if the expert whose opinion you like, if that expert used the identical approach, you might well disqualify the expert whose opinion you like. So there's that. I think another thing is that many of the approaches that mental health professionals employ are sort of difficult for lawyers to understand. They don't really have a good understanding. I think another part of it is, well, if we bar mental health professionals from offering expert testimony based on questionable techniques, then who do we look to on, or what do we rely on otherwise? So I would say, in my opinion, mental health professionals oftentimes get too much leeway with respect to what they get to base their opinions on, the techniques that they employ, much like that South Florida expert that I was talking to you about. If there is going to be a challenge, those challenges should take place with a fair warning and notice. I think that that would allow for adequate preparation by the expert to describe and defend their technique. They could devote some time to justifying the approach they employ. I think if an expert, a mental health professional expert, shows up to a hearing and gets challenges about the approaches he or she employed without any warning of a formal hearing, I think that's typically going to go to arguing that the judge should give that testimony based on the questionable techniques, give it less weight. On the other hand, a lawyer could make the argument that the testimony should be barred. And I think if that argument is made, I think there's going to be a hearing allotted for that. And that'll be typically discussed as a Daubert hearing or a Fry hearing, depending on the jurisdiction where this challenge is taking place. And we'll talk about those two decisions coming up here. For those who are not familiar, the first case I mentioned, Fry versus United States, 1923, criminal case in federal court. Harvard psychology professor wants to offer expert testimony about whether the defendant is lying or not when he denies having murdered the victim in the case. And the psychology professor's testimony about the truthfulness of the denial is based on a precursor to the polygraph. The psychology professor was a researcher who did some of the early research on what we now refer to or describe as the polygraph. The psychology professor is prepared to testify that when the defendant denies having killed the victim, he has an expert opinion that denial is truthful. You can imagine the prosecutor is not a real fan of this and seeks to bar the expert's testimony, and the testimony is ultimately barred, the court in this matter determines that when there's a challenge to the theory or technique on which the expert testimony is based, saying that it's certainly not a phrase in 1923, but certainly a phrase today, it's based on junk science, the judge makes the decision as to admissibility based on whether the technique is generally accepted by the relevant scientific community. If the expert and the attorney retaining the expert can convince the judge that the technique that the expert used is generally accepted by the relevant scientific community, then the judge should allow the expert to testify. Well, you can imagine, well, what do you mean generally accepted? Is that 6 out of 10 psychologists believe, or what does that mean? And what's the relevant scientific community anyway? Is it people who use the polygraph to ascertain whether people are being truthful or not? Is it polygraph research? So always more complicated than you think. And that was a test that was used, or a rule that was used for the longest time when an attorney was trying to bar an expert from testifying on the grounds that the technique from which his or her opinions flowed was not adequate, was not valid, was not reliable. Again, those kinds of challenges are uncommon even to this day. Some federal litigation, Daubert versus Merrill Dow Pharmaceuticals, 70 years later, the issue finds its way to the Supreme Court, and the Supreme Court proposes a different rule to be used, that when there's an argument that proffered expert testimony should be barred because the technique they employed was not valid or reliable, the judge should make a decision based on consideration of a number of factors, including but not limited to, was the technique that was employed, maybe it was a test, maybe it was a more general approach, was that technique subject to testing in terms of its accuracy? Are there known error rates? Or have they been established? Did the expert adhere to adequate standards? Has the technique, as a measure of something or tool to do something, has it been subjected to peer review? And is that technique generally accepted in the relevant field, which is sort of a nodding to Fry versus the United States? What's to take from this? I think it's rare that a mental health professional, where an attorney will seek to bar expert testimony from a mental health professional based on the argument that the technique or techniques the expert mental health professional employed are not sufficiently scientific or valid or proven. I think that's uncommon. Most mental health professionals who testify in legal proceedings will tell you they've never had such a challenge. If it occurs, you'll have fair warning. I'd be interested in knowing, are there any people in today's training who have participated in either a Fry or a Daubert hearing based on an attorney's efforts to bar them from testimony, making the claim that their assessment approach was not sufficiently valid / reliable? I think it's relatively uncommon. I've testified in 2, well, they were Fry hearings at the time. The law of the jurisdiction subsequently changed. Just so you know, we'll get to it later. New Mexico is a Daubert state. Anyone suggesting that they had that experience, Anthony?
Yeah, Caroline in the chat says she has. Yeah.
Caroline, do you mind unmuting and sharing with us what it was?
Sure. I've actually testified in several Daubert hearings. I am based in Wisconsin, and Wisconsin is a Daubert state. These were specifically related to
Let me guess, Caroline, let me guess real quick. sexually violent predator proceedings?
No, no.
Okay,
Good
all
guess
right.
though. Good guess. But no, these were kind of unique circumstances in that, in terms of the assessment process, but it was reviewing child forensic interview guidelines. So I was not necessarily doing an evaluation,
Sure.
but hired by, or attempted to be hired by defense to provide, um, oh my gosh, I can't even remember the word for it, but testimony about memory, about expert proceedings in child forensic interview guidelines, how to do them correctly, and then comparing the child forensic interview that was done in that particular case to best practice procedures.
Okay.
Um, and I got denied several times actually, to the point where it was becoming, I stopped taking the referrals because I no one would let me testify. It was interesting, and I don't know if that was a Wisconsin specific issue, um, but yeah, my colleague who I know you're familiar with, David Thompson, is also involved in that, and I was working under his office at the time doing these reports and these evaluations. And yeah, it was an interesting experience. Great testifying experience, but I ended up not being permitted to testify, I think, on three different occasions, which I know is unusual and rare compared to all my other psychologist colleagues.
So, so I assume you were going to offer testimony if you were retained by the defense. It was probably somewhat critical of the techniques or methods that had been used by some people who interviewed children
Correct.
for whom there was a question about whether they had been abused or abused, I assume. Yeah.
Correct.
And they were able to convince the judge that, and it was an actual Daubert challenge that were they suggesting that the research wasn't sort of developed enough, or that the approach your review of or the research you were going to, how did they craft that?
Good question, because the legal decisions were confusing to me and confusing to the retaining attorneys.
Mhm.
I recall in one particular case, and this is a couple years ago now, but in one particular case, they wanted to hire me to just provide testimony about memory. So not even necessarily criticizing the or critiquing
Techniques.
the initial interviewer's
Mhm.
methods, but just providing more contextual research background information to educate the jury on issues of memory and factors that can impact memory. And I think one of the reasons why they determined I was not allowed to testify is because they said that it didn't sufficiently fit the facts of the case,
Okay.
which I'm not going to argue with the judge, but I couldn't understand that. But yeah, those were my experiences.
In my two Fry experiences, because Texas, well, maybe Texas was it was expert testimony in Texas and expert testimony in Florida. Florida was definitely a Fry state at the time. I don't remember now as to whether Texas was a Daubert state at that time. It was certainly after 93, but uh, Daubert versus the Daubert test or standard may or may not apply in a particular jurisdiction, whether the state adopted it. But in any case, they were trying to bar expert testimony about recidivism risk based on particular tools, that is, a handful of actuarials. And in both cases, the experts were allowed to testify about recidivism rates in these hearings based on some of the actuarials that they had relied on. the Minsaw Star and the Razor, things like that. So, all right.
Exposition testimony was the word I was trying to think of that I couldn't think of a second ago.
Okay.
I was hired basically for exposition testimony.
Okay. All right. So here's a New Mexico case for the past State versus Alberico. There's been much criticism of the Fry doctrine, right? That's the sort of comes from that 1923 case, which has been uttered in mantra-like fashion by lawyers and judges alike as a precondition for the admission of expert testimony. Today, we abandon the Fry test as a predicate for the admissibility of scientific evidence by way of expert opinion testimony, relying instead on our rules of evidence. So the point is, if you go to New Mexico Rule of Evidence 702, which I just presented, if an attorney wants to bar the expert from testifying, you've got to look at those requirements, the 702 requirements, and the attorney's got to anchor his or her argument in the 702 requirements versus is the technique that the expert relied on generally accepted in the relevant scientific community. And then we get this case, Furstenberg, in determining whether scientific evidence has a reliable basis, read valid. Is it a valid technique to do what it says it does? The district court should consider whether a theory or technique can be tested, whether the theory or technique has been subjected to peer review and publication, the known potential error rate, how accurate is the technique, and the existence and maintenance of standards controlling the technique's operation, whether the theory or technique has been generally accepted in the particular field, whether the technique is based upon well-recognized scientific principle, and whether it is capable of supporting opinions based upon reasonable probability rather than conjecture. And you can see that the language in Furstenberg is very similar, not identical, but very similar to what the Supreme Court laid out 20 years prior, 22 years prior in Daubert. All that being said, rarely do lawyers seek to bar mental health professionals from testifying on the grounds that the techniques they employed were not sufficiently valid or scientific. All right.
Randy, I have a
Yes.
comment on Alberico, because we actually evaluated Alberico. It was a child sex offense.
Okay.
There was another psychologist in town who saw these children for evaluation, and she testified that she believed the children.
Okay. All right.
And that's what kicked the whole thing off, just for the background.
So expert testimony that maybe another witness, maybe the children testified or not, I don't know, but expert testimony that someone is telling the truth. Historically, the courts are very uncomfortable with that, right? That they don't want expert opinions about the truthfulness of witnesses. And there's a whole line of cases to that effect. It's interesting to know that the Alberico case came in that context. So
I thought you'd find that interesting.
Yeah, certainly. So let's think about this. What about, as you think about it generally, Ronnie Zamora, right? He was the one whose lawyer argued that he suffered from television intoxication. Many of you will remember the case of his name is escaping me now, a Jamaican man, Colin Ferguson. Colin Ferguson shot up the Long Island Railroad, killed a handful of people, injured many more. Attorneys that he briefly had wanted to argue that he suffered from black rage. That's what led him to shoot the other riders of the train, killing some, wounding others. What about if they want to prevent an expert from arguing that Ronnie Zamora suffers from television intoxication or black rage? What could the argument be? What's the science regarding a mental disorder or some kind of impairment described as television intoxication or black rage, right? Is there a science there? And how does one go about assessing to determine whether someone suffers from black rage or from television intoxication? Both, I will point out, both of these arguments were made by attorneys, not mental health professionals, right? You're probably not going to find a lot of science supporting a diagnosis or a condition noted to be television intoxication or black rage. What about schizophrenia, on the other hand? Or what about battered woman syndrome? Not in the DSM, probably all things being equal, not good for getting a court to allow discussion of it. But on the other hand, research by Lenore Walker and others regarding, I think battered woman syndrome's a little dated from a language perspective, but interpersonal violence and cycles of violence and things like that, maybe that would support allowing testimony about a woman, a person. It doesn't have to be a woman really, but a person subjected to violence at the hands of someone that they maybe go on to strike out against. What about an opinion that women are from Venus and men are from Mars? Well, after all, there's a book about it, right? There was a guy who got a bogus psychology degree years ago and wrote a very best-selling book, Women Are From Venus and Men Are Mars. What about an opinion the plaintiff is codependent, right? What about an opinion that the defendant is high in psychopathy based on a PCLR score of 34 out of 40, right? Well, what's the PCLR? What's the scientific support for the PCLR as a measure of psychopathy? What about opinion testimony that a parent is high in psychopathic traits based on how he recreated a design that's included in the Bender visual, the Bender Gestalt? So you can see how this might be treated, although I'm not suggesting that these kinds of claims have been subjected to Daubert or Frye challenges, but you can imagine how an attorney could argue this. I want you to prove the science of the PCLR. I want you to prove that the PCLR is a valid measure of psychopathy before you go testifying that my client is high in psychopathy because you gave him a score of 34 out of 40. What's the research examining the validity of the PCLR as a measure? What about inter-rater reliability? What about research regarding bias, et cetera? What about research examining use of the PCLR with people who look like my client as a defense attorney in terms of race, ethnicity, sex, gender, right? Maybe the attorney wants to bar the expert from describing his client as high in psychopathy based on the PCLR score. That being said, these issues rarely raise their heads in the cases of most mental health professionals who testify in court. In fact, most mental health professionals don't have any experience with efforts made to challenge their opinions based on claims that the technique upon which they rely is not adequately demonstrated to be valid or scientific or like that. Okay. Any questions about that?
We have a couple of things in the chat. A couple of people before on general admissibility were noting Tess Neal's article from several years ago about indeed this idea that Daubert or Frye hearings, that it's very rarely happens, let alone being successful. Somebody recollecting Static 99 being the most common where these come up in Tess's article. I think that connects to what you were referencing, Randy, when you guessed if Caroline's case was an SVP article, because that is the case where a Daubert dispute was successful, although I think part of that was more the contention about lack of data sharing in that hearing in and of itself than the actual admissibility of the static. But that kind of led to an onspring of precedent of it being not admitted in a Daubert hearing in Wisconsin. And then with these expert opinions discussions, I posted an article of one of my favorites of a psychologist referencing affluenza for a case of a teen who had driven while intoxicated, got in a wreck, and killed a couple of people died in it. And the psychologist said that because he had been coddled in a well-to-do parenting, that he was unable to understand his actions, or was told, basically that he didn't appreciate wrongfulness because of his condition. And then Andrew, of course, bringing up something that's come up a lot in some cases in the past couple of years about in forensic science and all that, about excited delirium diagnoses.
That affluenza case, that was a Texas case, I remember, and it's literally embarrassing, right? That one of our peers would think that it's a good idea and maybe the psychologist was admitted, maybe he was appropriately limiting in terms of how he portrayed it. It's almost as if but it just didn't play very well and did not make mental health professionals look good. But really, it made it look like just a ploy to assist the defendant in avoiding responsibility for, I think, was a motor vehicle accident that resulted in some people dying, I think. But if you're coming up with new terms that have never been referenced or cited before, that maybe suggests that you want to be careful about. There was a man, a middle-aged white man in the Florida Panhandle, who shot and killed a physician who worked at a women's health clinic where he provided abortions. And the man who killed the physician laid in wait and killed him. His attorney had proposed a defense of abortion clinic mania, which is sort of right up there with television intoxication or affluenza. But I don't think most experts, I think most experts would be savvy and insightful enough to avoid invitations from attorneys to offer testimony in those kinds of formats. Let's continue with some of these New Mexico rules of evidence. So here's one I thought was worthy of discussing. This is verbatim, New Mexico Rule of Evidence 703. You can find a similar federal equivalent, FRE 703. An expert may base an opinion on facts or data in the case that the expert has been made aware of or personally observed. If experts in the particular field would reasonably rely on those kinds of facts or data in forming an opinion on the subject, the facts or data need not be admissible for the opinion to be admitted. But if the facts or data would otherwise be inadmissible, the proponent of the opinion may disclose them to the jury only if their probative value in helping the jury evaluate the opinion substantially outweighs their prejudicial effect. That's a lot of words, okay? But I think it is an important rule. Experts may base an opinion, an expert opinion, I assume, or facts or on facts or data that have been shared with the expert or the expert has learned of himself or herself. If experts in the field would reasonably rely on those kinds of facts or data in forming an opinion, the facts or data need not be admissible. So experts can form opinions if, even on inadmissible data, as long as other experts would reasonably rely on that kind of stuff. So here's a great example. Experts can form opinions in part based on reviewing mental health treatment records. Experts can form opinions based in part on reviewing mental health treatment records. Is that a reasonable way to form opinions about people you're examining? I think you would say yes. That's one source of data, right? You would look at records. Those records may not be admissible because maybe there's a hearsay objection, but you still get to offer the opinion. You still get to offer the opinion based on evidence, data that's inadmissible. And the catch is you may be barred from saying, well, my opinion is partly based on review of records, because that might be considered prejudicial in some way. And there is this exception here. So can an expert offer an opinion based on data that are otherwise inadmissible? The answer is yes, providing that it's the kind of data that people in the expert's field reasonably rely upon. Okay? Is it reasonable when you're forming opinions about people you're examining to rely on records of mental health treatment, as I was suggesting? Yes, it is. Okay? You need not worry about the admissibility issue. However, you may be barred from testifying, well, one of the reasons I formed this opinion is the mental health treatment records I reviewed, X, Y, and Z, unless they can otherwise get those mental health treatment records in, maybe by having them validated or verified by the author of the records or something like that. And this happens all the time, by the way, right? Mental health professionals routinely form opinions about the people they examine based on data that are otherwise or might not be inadmissible. That's okay. That's okay. But an important point. Another point, an opinion is not objectionable just because it embraces an ultimate issue. All right? Okay. So what does this mean? Expert witnesses are not prohibited from offering opinions like the defendant is competent to stand trial, or the defendant meets criteria for involuntary hospitalization. Those are ultimately legal issues that are be decided by a judge, right? Judges decide whether people are competent or incompetent to stand trial. Judges decide whether someone meets criteria for involuntary hospitalization or not. But experts are allowed to offer opinions in New Mexico on what are ultimately legal issues. Now, whether experts should offer opinions on what are ultimately legal issues has long been debated, okay? We know a few things. One is attorneys and judges often want these opinions, right? Attorneys and judges. Mr. Examiner, is the defendant competent or not competent? We want to know your opinion. Yes, it's ultimately an opinion for a decision for the judge to make, but what do you think? Examiner, do you believe he meets criteria for assisted outpatient treatment? Yes, it's ultimately a legal issue, but we'd like to know what you think. There's actually research suggesting that attorneys and judges in many criminal proceedings demonstrate a preference for the mental health professional to offer opinions on the legal issue. We also know that most mental health professionals are willing to offer such opinions. If you look at any research where they summarize, where they conduct research describing reports that summarize forensic mental health evaluations, most of those reports include mental health professionals offering opinions on what is ultimately a legal issue. The argument against mental health professionals writing or testifying, in my opinion, the defendant is competent or incompetent, is ultimately that's a legal issue, not a psychological or psychiatric one. And the mental health professional doesn't have the requisite expertise and may be lacking data. It's for the judge. those same people would say, oh, the mental health professional can be helpful to the judge if they describe the defendant's functioning and adjustment as it gets to their ability to work with their attorney or understand and participate in legal proceedings, but they shouldn't weigh in on what are ultimately legal issues. Those who argue that the mental health professional should write it or testify to it say, look, the judge just wants to know, the lawyers just want to know. Believe me, they're willing to form an opinion that's contrary to what the mental health professional forms. They would just like to know. And that's why they hired you. And this debate goes back and forth. I would say that debate may be less important, providing the mental health professionals who do offer such opinions support their opinions with a rich description of the facts and the reasoning underlying their opinions. Judge, I recommend you adjudicate this defendant competent to stand trial, and let me give you all the facts and the reasoning that support my opinion. And then you can see whether you adopt my facts and reasoning. I think where we get into problems, the real concern is a circumstance where all the mental health professional does, or mostly what the mental health professional does, is simply offer the opinion without their underlying facts and reasoning. That's probably more concerning. But I will tell you, it's really, really interesting, right? That in my experience, if a mental health professional doesn't offer an opinion about a defendant's competence or incompetence to stand trial, the attorneys and the judge may be very disappointed, may be upset. But there's other kinds of proceedings where they will be very upset or disappointed if the mental health professional does weigh in. I've seen judges and lawyers take mental health professionals to task for arguing that in their report, the defendant's waiver of his Miranda rights was involuntary, or he did it without an adequate understanding of his rights. I've seen lawyers and judges say, doctor, don't you know that's a legal issue? That's not a psychological one. That's no more a legal issue than whether the defendant's competent to stand trial or incompetent to stand trial. So I've seen some interesting inconsistencies there. But in my experience, generally, I found, at least in criminal proceedings, that lawyers and judges very much want the mental health professionals to weigh in on the legal issue, whether it's competence, criminal responsibility, criminal commitment, as an example. I'd be interested in knowing if people have other perspectives or experiences in this arena. And please feel free to unmute or enter something into the chat for Anthony to share with us.
We don't have anything added in the moment. I'll add that at least about a year and a half, 2 years ago, when we had on the Law and Mental Health series, we had a panel of a couple of judges talking about, among other things, this issue. And at least for them, one of the things that they separated in commenting on the ultimate opinion from their perspective is they seem to have different opinions on their comfort with experts sharing the ultimate issue as a factor of if the decision was ultimately going to be made by them as a judge versus a jury decision. And they expressed that they felt more comfortable hearing about ultimate opinions on things where they, as the judge, would make a determination on, say, competence. But something like insanity, if there was an insanity defense and it would be a jury decision on a verdict, they were much more reticent to have an expert give an opinion on an ultimate issue that a jury would ultimately be would be responsible for deciding.
Yeah, I'm not surprised by that, because I can imagine a judge thinking, I'm in a better position than members of the jury to assess the adequacy of the expert's technique, to not be overwhelmed by the expert's supposed expertise, given my experience and training, that I can do a better job of resisting maybe rolling over to the expert or something like that. That doesn't surprise me that they expressed more concern when it was a jury that might be hearing that ultimate issue testimony versus themselves. That doesn't surprise me. Okay. Anything come in by way of the chat, Anthony?
No.
All right. Okay. What about offering opinions without underlying facts? What about writing a report where you offer opinions, but you don't offer the facts, or testifying where you offer opinions, but not the facts? This is what New Mexico Rule of Evidence 705 says. Unless the court orders otherwise, an expert may state an opinion and give the reasons for it without first testifying to the underlying facts or data. But the expert may be required to disclose those facts or data on cross-examination. Now, a couple points here. One is I want to say that best forensic practice recommends that we offer a factual basis for all our important opinions. If we're going to opine that the defendant's ability to communicate and work with counsel is limited, that's an opinion, we should support that with facts. That's best practice, not simply offer the opinion, but the opinion supported by the facts immediately before or immediate after. But one need not provide a factual basis for one's opinions. Push comes to shove, of course, is you can be required to provide the facts for any opinions that are offered, and that's typically going to come ultimately by way of cross-examination. Now, during direct examination, you could get a question, Doctor, what's your opinion about the defendant's ability to work with his attorney? Well, in my opinion, his ability to work with his attorney is very limited. The next direct examination could be, and why is that? What did the defendant tell you? Or what did the defense attorney tell you that leads you to the opinion that his ability to work and communicate with his attorney is very limited? What are the facts underlying that opinion? And then you give them out. There's no need for the cross-examining an attorney to get to this, because you've already disclosed it. But what we need to keep in mind is, one, best forensic practices, we always provide the factual basis for our opinions, for our important opinions. And two, if we don't, we can always be forced to provide the factual basis. So imagine this. The defendant's mother is willing to answer your questions about his developmental, mental, and mental health history, because you're doing a competence examination. You reached out to the mom. Could you tell me a little bit about your son's developmental history, his medical history, his mental health history? He's not the best historian, but she's only willing to talk to you on the condition that you grant her anonymity and you agree not to identify her as the source of any information. She'll talk to you all day about her son and his history, but the condition is you can't identify her as an information source in your report or when you testify. So any thoughts about how you would respond to her request here? And keep in mind, you think about the rule that we just reviewed. Any thoughts about what you could do with her here, assuming she's standing hard on this issue? Anyone want to unmute or use the chat function? Any discussion, Anthony?
Not yet, though it's possible people could be typing.
Okay. Anyone want to unmute and tackle it?
I think for me, the issue would be that, if the information that the mother provides is going to provide that factual basis for an opinion, and if I don't put that in the report, that's one thing. But if I go to court and they're like, well, how do you know this information? That's where that leads, is I have to say, oh, I got it from the mother, and I wouldn't be able to promise her anonymity or to keep this anonymous, at that. I mean, I would kind of lean, what I do would be a bit different, but I think that that's kind of the issue, is I want to be transparent about the source of the information, not just what the information is.
Sure. And I mean, one approach would be, okay, well, I'll take her at this. I'll question her. I'll get information and answers to my questions, and then I won't identify her as a source of information when I write the report. So I'm not going to even indicate that I interviewed her because she wants that anonymity, and I'll report her assertions that I think are relevant, and I won't identify her as the source of information. One, I think it's misleading to have sources of information that you don't disclose as sources of information. That's problematic. And two, even if you did that, you could be forced, as you say, how do you know that he was born a month prematurely? How do you know that, doctor? I refuse to tell you because I guaranteed the source of information anonymity. I guess you could testify to that. I don't think that's going to go over well, right? I think you're going to be ordered to answer the question at this point if the questioner is adamant, in which case you're going to breach your promise to her. So I don't think we can go forward in this case with questioning mom, given the conditions that she has laid out for us, right? Given, among other things, this rule of evidence, along with what I think is reasonable and appropriate forensic practice. I think in the interest of transparency, we're going to identify all our data sources and tie any data that we get from our data sources to the sources themselves in the body of the report, affirmatively disclosing that. So I don't think we can grant the mother her wish, maybe foregoing some valuable information. But I think that's what we're left with. How about this? Now, in order to make my point, I had to move to a different kind of evaluation. I know that's not the focus of this program, this 2-day program, but imagine you were doing a sanity evaluation. Conducting a sanity evaluation, you review records documenting mental health treatment the defendant received when in prison, where he was serving a prior sentence for manslaughter. The treatment records are important to you in that your opinion that the defendant has a documented history of schizophrenia that predates his arrest on the current charges. So he received mental health treatment in prison, serving a prison term for manslaughter. He's now in a criminal court again. You're testifying about his mental state at the time of the offense. You're going to talk in part about the fact that he has a documented history of schizophrenia and treatment that predates his arrest on the current charges. So you're going to be testifying in front of the jury in this sanity hearing. I think we all know that it's going to be problematic if you say something like, well, a few years ago, the defendant was convicted of manslaughter and he was sent to prison. And when he was in prison, he received mental health treatment for a diagnosis of schizophrenia, right? We're all familiar with the idea that it's probably not, it's problematic if the jury learns of the defendant's prior conviction, right? That's typically something that's kept out of the jury's awareness. So if you're going to look at the prison mental health treatment records, if you're going to rely on them, how might you manage your testimony thinking that it's going to be a problem if you say, yes, the defendant was convicted of manslaughter in the past, he was sent to prison, I got the prison treatment records, he was diagnosed with schizophrenia, that's important, and this is why. How might this be handled? This is actually a case that I had a few years ago. How might you handle this? Any thoughts? In the report that I wrote, which of course wasn't going to the jury, the report that I wrote, I listed in sources of information records of mental health treatment at Florida State Prison as an information source. In the report that I wrote, I also talked about the contents of the record. When he was at Florida State Prison between 1995 and 2000, serving a sentence for a manslaughter conviction, Mr. Jackson was seen by mental health staff. He was diagnosed with schizophrenia and treated for that. That was all fine, but the attorneys made clear you can't mention prior conviction, you can't mention time in prison, mental health treatment in prison. So what did I testify to? I testified that for the jury, I testified that I had reviewed a number of documents, including documents referencing prior mental health treatment, not in a prison, not while serving a sentence for manslaughter. And I talked about the contents of the record. He had been seen by mental health professionals. They offered a diagnosis of schizophrenia and provided these different medications to treat his schizophrenia, excluding the fact that it occurred while he was in prison subsequent to a conviction for manslaughter. I was able to talk about it in that general kind of way, so it wasn't problematic from the prejudicial kind of thinking, and all was fine. Again, I apologize for using a case outside the scope of the training to make the point here. All right. We are right at noon. What I suggest is that we take our midday break here. For many of us, that'll be lunch. And I think I propose that to be 45 minutes. So I suggest we take our break now and reconvene at 45 minutes after the hour. I'll finish up the discussion of rules of evidence and law devoted to competence. That'll get us to mid-afternoon, and then at that point, I'll turn it over to Anthony to begin his discussion of clinical evaluation. Okay, so if everyone's agreeable, let's take our break till 45 after the hour, and then we'll restart at that point, 12:45. I suggest that everyone stay logged in, and then we'll see you in 45. See you then. All right, I think I have 45 after the hour, so we can continue. We just have a few more rules of evidence to discuss, and then we'll move into some other content. I found this interesting in that there is some explicit discussion of appointment of experts in competence proceedings in the New Mexico rules of evidence, which you wouldn't find in the federal rules of evidence. So earlier this morning, I was saying that oftentimes states' rules of evidence parallel the federal rules, but here's an example where the New Mexico rules and the federal rules really part. And we'll also be talking about these issues when we get to New Mexico code, I think, or rules of criminal procedure about the appointment process. But here's some things just to quickly review. Court can order appointment of experts to conduct examinations. It could be an expert that the parties agree to, or the court chooses, and obviously the examiner must agree to participate. Can't be appointed over objection. This lays out the role of the expert when appointed by the court, including advising the parties of any finding the expert makes, availability for deposition, being called to testify either by the court or either of the parties, and being cross-examined by any party, including the party that called the expert. That really makes sense, I think, insofar as one of the parties, one of the attorneys might want to have the expert there explicitly for cross-examination to challenge what might have been suggested in the report. There's specific language regarding compensation of the expert. And then I found this interesting too, an allowance that the court may disclose to the jury that the court appointed the expert. This is news to me, insofar as it suggests that the competence question could be determined by a jury. That was news to me. I'm interested in what people have to say about that. Even if there's a court-appointed expert, that doesn't prevent either party, defense or prosecution, from calling its own experts. Just a couple constitutional issues when it comes to competence examinations throughout the United States, including New Mexico. Very important case. Estelle versus Smith out of Texas. The defendant in this case was ordered to undergo a competence examination by the court. Defense counsel wasn't notified. The defendant was examined, and then statements that the defendant shared with the examiner were used at the time of sentencing. I think quite obviously, when this was appealed and found its way to the Supreme Court, the Supreme Court ruled that if the court is going to order an examination under the Fifth Amendment, the defendant would have the right to remain silent and refuse participation unless the results are used only to inform competence decisions. Otherwise, defendants could be forced to participate in competence evaluations under penalty of maybe contempt of court, forced to make statements that are potentially incriminating, which would be a violation of the right to remain silent. That makes the utmost sense. I'll also point out that New Mexico really doesn't need Estelle versus Smith, because it's quite clear, based on New Mexico statute, that potentially incriminating informations the defendant might make during the course of a competence evaluation can't be used for purposes of adjudicating or proving guilt or responsibility. So now maybe the better way to talk about that is that Estelle versus Smith stimulated New Mexico law, sort of memorializing it statutorily. But in any case, Estelle versus Smith is wholly consistent with, or New Mexico law is wholly consistent with, the court's finding in Estelle versus Smith. A secondary holding was that the defendant has the right to have counsel notified of such a court-ordered examination. Here we're going to New Mexico rules of criminal procedure now. And here's the point I was just making. A competence evaluation, according to Mexico Rules of Criminal Procedure, shall not state opinions about other matters at issue in the criminal case, including the defendant's sanity or ability to form specific intent. So if you remember earlier this morning, I was talking about components of an appropriate forensic examination. It would be addressing the referral question and only the referral question. So here's some very focused guidance from the New Mexico Rules of Criminal Procedure about some things that shouldn't be addressed, including mental state at the time of the offense or ability to form specific intent, maybe from more like a diminished capacity or mens rea perspective. In addition, there's this language, the report, the competence evaluation report, shall not include information or opinions concerning the defendant's mental condition at the time of the alleged offense or any statements made by the defendant regarding the alleged offense or any other crime. So this is why I say that the New Mexico law or rules are very consistent with and sort of embody the principles identified by the Supreme Court in Estelle versus Smith, a real effort to ensure that a defendant's not prejudiced by participation in a competence evaluation where the results of the evaluation would be used elsewhere in the coming about that later. Although this won't prove relevant in New Mexico competence proceedings, I will reference this Sixth Amendment concern as it applies to sanity evaluations. Supreme Court decision again, Crawford versus Washington. Defendants have the right to confront their accusers such that statements made to state investigators, meaning the prosecution, may be inadmissible unless the witness is in the courtroom dead or asserting the Fifth Amendment. So this is sort of a Sixth Amendment right to confront accuser claim. And then this is not a federal decision. This is not a New Mexico decision. This is a really interesting case out of New York State, People versus Goldstein, where the New York court decides that this Crawford decision confronting accusers and the Sixth Amendment applies to witnesses who are relied upon by the prosecutors, forensic examiners. People versus Goldstein was an interesting case. The defendant had pushed a young woman in front of a subway car and she died. Goldstein was the defendant's name. He was prosecuted for her death. He was pleading not some mental state defense. The prosecutor hired a forensic psychiatrist to examine Goldstein. And in her forensic psychiatric examination, the psychiatrist interviewed people familiar with Goldstein. I believe it was a landlord and maybe a prior roommate. Forensic psychiatrist, I think, was doing a good job of conducting a sanity evaluation, trying to get insight into Goldstein's mental functioning generally, as it would be relevant to an insanity defense. So she goes about interviewing collateral informants. I believe it was an ex-roommate and then a landlord or ex-landlord. And I guess the interviews that she carries out, she cites in support of her opinion, suggesting that Goldstein was not as impaired as he otherwise might be, or you otherwise might think he was. So she forms an opinion that Goldstein's was not significantly mentally impaired, which obviously goes to challenge his mental state defense. And she discusses her interviews of these two collateral informants. Goldstein argues that the psychiatrist reciting what the collateral informants provided her in terms of their opinions, maybe not opinions, but observations of Goldstein. When those informants weren't available, maybe to be cross-examined by Goldstein's lawyer, did you talk to the psychiatrist? Did you tell the psychiatrist that he wasn't that impaired or whatever else, right? That they shouldn't be stuck relying on the psychiatrist's recitation of what the collateral informants gave her, but they should have available those witnesses to challenge, but they weren't there. So this was hearsay, obviously, out-of-court statements upon which the psychiatrist relied. And they used that to appeal the conviction. The appellate court ruled that this right to confront accusers applied to collateral informants upon which the prosecutor's forensic examiner, forensic psychiatrist relied. Now, some people read this and they say, oh my gosh, if you're doing a sanity evaluation and you're hired by the state, the prosecutor never talked to collateral witnesses. I don't think that's the take-home message. I think if you're conducting a sanity evaluation for the prosecution and you think it's important to talk to some collateral informants, I think you talk to them. I think the impact of this decision, if it holds in New Mexico, would be that if you're going to interview the informants and you're going to offer your opinions about the defendant's mental state and cite what the collateral informants told you, then it's incumbent upon the prosecutor that either they get the defense to say, don't worry about bringing those collateral informants in, or, oh no, I don't want Dr. Otto talking about what those informants told him unless those collateral informants are made available for me to cross-examine. To just ensure that Dr. Otto's representation of what they said was actually what they said. So again, this doesn't apply to competence proceedings, but it is a constitutional issue that I thought you would find interesting to think about while we were talking about constitutional concerns like Estelle versus Smith in the competence context. All right. So what should we get out of all of this? The expert should make sure that he or she's qualified to carry out the examination around issues of education, experience, and the evaluation procedure. The testimony should be based on specialized knowledge, things that the mental health professional knows that lawyers, judges, jurors don't know if it's a jury proceeding. And that would allow expert opinions because the opinions are based on specialized knowledge, that reliable, that is valid, right? Reliable is the legal language. Valid theories, valid principles, valid techniques are employed as part of the evaluation. The facts that are available to you are adequate and valid, established, and the opinions included in the report, included in the testimony, are limited to those opinions that should be provided. Think about the exclusions for opinions about mental state at the time of the offense, incriminating information, mens rea, things like that. All right. I want to talk a little bit about the stages of the criminal process before we get into competence law in New Mexico for a number of reasons. One is we're evaluating, we work in the legal system and we're evaluating people who are in the legal system. It's helpful to know the process generally because you might get an idea about useful and relevant information that might be provided at each stage in the criminal process. Different stages of the process can trigger different constitutional obligations and protections and other legal rules protections. And if at some level we're going to make judgments about a defendant's understanding of the legal process, we should probably be reasonably knowledgeable about the legal process. All right, well, let's think about pre-adjudication, arrest and booking. Where do we get the term booking? Because historically, when people were arrested, their name and demographic information were included in a big book that the jail maintained. In fact, if you ever go to maybe you find a jail museum or something like that, many of them will include copies of the old book. There'll be a date of admission, maybe the name of the person, their sex, age, maybe race, and then the charge that they were brought in on. It's just one line after the other, and these books were just collected over time. So there's arrest and booking. The person may or may not be questioned before or after the arrest. That would be an interrogation if they're detained. If they enter the jail, they're likely to be interviewed and examined by jail medical and classification staff. Sometimes they might not get that far before they have a first appearance or something like that. In other cases, they may make it that far and they may be around long enough to get interviewed and classified by medical and correctional staff. At some point, there's going to be a first appearance. People are notified of their rights. There may be appointment of counsel, either temporarily or not temporarily. There has to be some consideration of probable cause. Does the presiding judge or magistrate have reason to believe that the arrest and detention was justified? In some really minor cases, there could be a hearing or trial or plea agreement, but it's going to have to be a really, really minor case. In most cases, there's decisions about bail and release, appointment of a defense attorney, particularly around eligibility for public counsel and things like that. So let's assume the person has been arrested, they've been charged, they may or may not be back in the community. Maybe they were released on their own recognizance, maybe bail was required and they were able to meet conditions of bail. So now their case is moving forward. There's the discovery process that includes a variety of things. It could include motions by the defense to suppress or limit evidence. They want to have the confession suppressed because there wasn't adequate notification of right to remain silent after an arrest and detention. So suppress what was learned during the interrogation. Could make a claim that the person was notified of their rights but lacked the capacity to understand and make sense of them. Or there might be they had no basis for an arrest or search or whatever the lawyers might argue. There could be examinations that take place during this time. Maybe this is where the defense goes to the court and says, I think my client might be incompetent. Judge, I'd like you to appoint an examiner. The defense could hire their own expert if they wanted. What's the advantage of an ex parte evaluation? The results only go to the defense until they perhaps identify that the expert might be testifying further down the line. For court-ordered competence examinations in New Mexico, the results go to all parties, both parties, and the judge, the motion for examination can be made by any party. And then ultimately there's adjudication. Trials are very uncommon. Overwhelming majority of criminal defendants enter into a plea agreement where they admit responsibility for some offense. Oftentimes, in exchange for a guilty plea, charges may be diminished in severity. So felony battery on a law enforcement officer becomes resisting arrest without violence. Sometimes charges are fully dismissed. You're charged with 4 things. If you'll plead guilty to 2, we're willing to forego to dismiss 2 of the charges. That's going to be by way of a plea agreement. Oftentimes, people refer to this as plea deals, plea bargaining. If there is going to be a plea agreement at some point, the judge is going to address this issue in open court, and the defendant is going to have to admit responsibility for something. This will be a hearing. Typically, the prosecutor is asked to provide a factual basis for the charges, where the prosecutor will typically use the arrest report and charging document to represent to the judge and the defense what's being alleged. The defense attorney gets an opportunity to dispute what the prosecutor might offer. All of this, of course, is being recorded by way of a court reporter during the hearing. And then the judge will say something like, my understanding is that there's the state and the defense have reached an agreement whereby the defendant will admit responsibility for some offense or some offenses. And there'll be an acknowledgement from both attorneys that that's the case. Then the judge will spend some time with the defendant asking questions like, Mr. Jackson, my understanding here is you've had adequate time to consult with counsel and you've decided that it's in your best interest to admit responsibility for the charges as we previously discussed. Ask questions like, how old are you? How far have you gone in school? Or are you under the influence of any drugs or medication as you sit here? Do you believe you've had adequate time to consult with your counsel? Do you believe it's in your best interest to admit responsibility for the offenses or the charges that were previously mentioned? Do you understand that you are presumed innocent? You have the right to a trial, and you're waiving those rights. You have the right to confront accusers, all of that. And it's a bunch of yeses and yeses and yeses from the defendant in a very, very much an orchestrated, quick way. And then the defendant will be apprised of things like, do you understand that you might be waiving some rights to appeal? Do you understand that a criminal conviction could affect your immigration status? Maybe if that's an issue for the defendant. But basically, it's on the record showing that the defendant made his decision voluntarily and knowingly. Mr. Defendant, have you been coerced or pressured in any way to enter into this agreement? Do you understand, again, that you could demand a trial and would have to be proven guilty beyond a reasonable doubt? It's very, very robotic, in my opinion. It's very hurried, and it's almost treated as, we got to get through this, which doesn't make for the most reassuring process, I think. But in any case, that plays out. And obviously the defense, well, maybe not so obviously, in most cases, the defense and the prosecution have not only entered into an agreement regarding what charges might be dismissed, what charges might be pled down, felony to misdemeanor or something like that, but almost always there's been an agreement as to the penalty that will apply. Sometimes they might leave it to the judge. That sometimes gets referred to as an open plea. But in my experience, most of the time, the defense and the prosecution have agreed to a particular sentence or disposition that obviously represents a sentence or a disposition that is lesser than the defendant could receive if all of the charges remained in place and he was convicted of all of the charges. That's the deal, right? That the defendant admits responsibility for some criminal conduct, avoids responsibility for other criminal conduct, and gets a sanction or disposition that is something lesser than he could get if he failed to admit responsibility and demanded a trial. That's what the defendant gets. What does the prosecutor get? The prosecutor gets a guaranteed conviction by way of the guilty plea in most cases, and avoids the challenge and headache of a trial. So too does the defense and defense attorney avoid the challenge and headache of a trial. If there is a trial, there could be selection of a jury. If no jury, then a bench trial. The state has the burden of proof regarding the offense. That burden, of course, is proving mens rea, the guilty mind, the mental state requirement, and the act that the defendant engaged in. The standard of proof is beyond a reasonable doubt. The burden of proof is on the state to prove all elements of the crime to the standard, which is beyond a reasonable doubt. Post-adjudication, the judge will sentence in a plea agreement. It will likely be to the sentences agreed to by the prosecutor and the defense. If the state has a death penalty, if the defendant is convicted and the state is seeking the death penalty, then a jury will sentence based on consideration of aggravating and mitigating factors. Aggravating factors include things like torture of the victim. Maybe in some states, the victim was a law enforcement officer engaged in, carrying out his activities. The victim maybe was disabled or impaired in some way. These are all factors that argue in favor of the death penalty. Some states, for example, Louisiana, Oregon, have risk for ongoing violent behavior as aggravating factors. Mitigating factors are factors that argue against the death penalty and an alternative sentence, for example, life in prison, something like that. In my experience, states list aggravating and mitigating factors statutorily. They identify them with the understanding that the defense has a lot of latitude in what it cites in terms of mitigating factors or mitigating circumstances. Oftentimes, in capital proceedings, the defendant will undergo an evaluation by a mental health professional, by a defense retained mental health professional who, ideally from the defense perspective would find a host of mitigating factors. Might also undergo examination by a prosecution retained expert who might, from the prosecution's perspective, who's seeking the death penalty, could come up with aggravating factors. Just to keep in mind, right now in the United States, Constitution prohibits the death penalty for people who commit first-degree murder before they turn 18. That was Roper versus Simmons in 2005, or people who are determined to have an intellectual disability. That was Atkins versus Virginia in 2002. A lot of times, these death penalty hearings after the conviction can revolve around questions of intellectual disability, with the defense claiming that the defendant has an intellectual disability, maybe the prosecution challenging that. Obviously, to disqualify someone from the death penalty simply based on the fact that he's was not an adult at the time of the murder is not left to a hearing. All that needs to be established is at the time of the offense was the person under the age of 18, and they escaped the death penalty there. So what are the implications of all of this for court retained examinations where you're ordered by the court to conduct the evaluation? I recommend that we tell defendants their statements may be used to assist the judge to determine their competence and inform things such as treatment decision-making. This, of course, is a response to recent legislation that requires examiners to weigh in on issues of whether the defendant meets criteria for civil commitment. Whether the defendant meets criteria for commitment and whether the defendant meets criteria for assisted outpatient treatment. I think we should tell defendants that their statements should not be used at trial or sentencing unless they try to use the results of the evaluation for some other reason. So they should gain some assurance that what they tell, that one, the purpose of the evaluation is not to prove them responsible or prove they committed the offenses, but rather the focus of the evaluation is, number one, helping the judge make a decision about whether they're able of working with counsel and moving forward with the legal process, and inform things like treatment decision making around commitment and AOT matters. All right. Couple case problems. The court ordered evaluation of the defendant's competence to stand trial. The defendant is agreeable and willing to answer your questions. Despite your repeated efforts to educate her, it's apparent the defendant has no understanding of the nature and purpose of the evaluation, quite likely due to the mental disorder that likely resulted in the defense attorney petitioning the court for evaluation of the defendant's competence in the first place. Do you perform the evaluation? Well, we covered this case already. Susan Cave sort of talked about, what do you do if you have a defendant who is willing to move forward, but clearly can't appreciate the nature and purpose of the evaluation despite your best efforts, presumably because of some kind of mental disorder they're experiencing that may well have been partly responsible for the request for the evaluation in the first place. As we talked about earlier this morning, I think the response is, yeah, you perform the evaluation. One is number one, you have the authority of the court order. And at least if you're a psychologist, from your ethics code, you have the tacit approval on the grounds that part of the purpose of the evaluation in part is to assess the defendant's decision-making abilities. Here's another case. We didn't cover this. What about this? You examined the defendant as ordered by the court. She was adjudicated competent and she entered a guilty plea. Okay. Now you learn that a sentencing hearing is coming up and the prosecutor reaches out to you and asks that you appear and testify about the defendant's history of violence as affected by her mental disorder, which you discussed in the report summarizing your competence examination. And this is a sentencing hearing. The defendant will receive some kind of criminal sanction from the court. The prosecutor, it looks like, wants to argue in favor of a greater sentence than a lesser sentence, in part because the defendant has this history of violence stemming from her mental disorder. Want you to come in and testify about that. You included that discussion in your report. The question is, can you participate in this hearing? If yes, why? And if no, why? So does anyone, given what we talked about this afternoon, have a thought about what they can or can't do here? You can use the chat or you can unmute. Anyone? We getting anything, Anthony?
Not yet on this. Susan earlier, clarified some procedural things here about arraignments being done at the magistrate level. And then when competency is raised, that's when things get bumped to district court in this area. We have you can't participate in this hearing unless you're, I guess, Dr. Death, Jack Kevorkian.
Yeah, Right. Well, not Dr. Kevorkian. That was the guy who would help people bring about their
Oh
own.
yeah, that's what I
Dr.
first think of when I
Grigson.
think Dr. Death. Yeah.
Dr. Grigson. They both had the nicknames of Dr. Death.
Yes, fair. Yes, wrong Dr. Death
James
for my
Grigson
part.
was
Yeah.
James Grigson was the forensic psychiatrist who
Yeah.
evaluated Mr. Smith in the Supreme Court case of Estelle versus Smith. It was a court-ordered examination, so the defendant participated, and then not only did Dr. Grigson testify around issues of competence, he also testified at the sentencing hearing. By the way, Mr. Smith was facing the death penalty, so at the death penalty sentencing hearing, Dr. Grigson testified based on information that he gathered during the competence evaluation. And one of the things he testified to was that Mr. Smith was a very high risk for a continued violent behavior. And this was challenged by counsel. And if you remember, Estelle versus Smith says that defendants do have a right to refuse the Fifth Amendment right to remain silent can apply in competence hearings unless the information used is limited to the competence hearing itself. So this would clearly be a violation of Estelle versus Smith. You evaluated the defendant by way of a court-ordered examination. You presumably told the defendant, listen, Mr. Jackson, whatever we talk about will only be used to inform opinions about competence or treatment matters. You didn't say anything about criminal sentencing or anything like that. So if you were to participate in this hearing, not only would it be a violation of Estelle versus Smith, but it would be a violation of those related New Mexico rules of criminal procedure where they talk about not addressing the information relayed during the court-ordered competence examination being very limited in terms of its application. So violation of Estelle versus Smith and New Mexico rules that are consistent with the spirit of Estelle versus Smith. All right. Any questions about any of that?
Somebody asked, would the same be true for dangerousness hearings for AOT civil commitment stemming from a finding of incompetence?
Well, that's up for discussion, right? The competence statute itself has been revised to direct examiners to address issues as part of the competence evaluation, getting to assisted outpatient treatment eligibility and commitment eligibility. At the same time, the legislature left remaining in New Mexico statute discussion of how limiting very much these opinions. So I don't know how this is going to play out. I could imagine a defense lawyer arguing the results of this competence evaluation should only go to determine whether the defendant is competent or not. It shouldn't be used to inform decision-making on the commitment or the AOT issue. The competence statute as it exists, we talked a little bit about this in our training earlier this spring, Anthony. The statute as it exists talks about examiners addressing these issues, presumably in anticipation of that information being shared. So I don't know what the court would do if that argument was made to it by an assertive defense attorney. No, it's clear that the results of this should only go to competence matters, not matters about commitment or AOT eligibility. That being said, the examiners are directed not only to address the competence issue, but the commitment and the AOT matters. It could be cleaned up. I mean, the potential conflict could be remedied by just cleaning up the statute. I don't know if that'll happen. I don't know if defense attorneys have made that argument, that there is this conflict apparent conflict within the competence statute. I don't know if you want to add anything, Anthony.
Yeah, we'll definitely get into that next week when we'll talk about the sections of AOT and commitment eligibility. But yeah, as Randy said, this is your active ongoing discussions with the state about this seeming conflict of what are our purposes now, but also this old language about the restrictions of what we can comment on. And I have seen people subpoenaed to testify at dangerousness hearings, and defense attorneys objecting to the relevance of such testimony for the dangerousness hearing.
Sure.
Well, Anthony, I think the contract specifies that we talk about the treatment needs of the individual and that we specifically address AOT and/or civil commitment. I think that's in the current contract because I was never asked to do this before July 1 this year.
It's in the contract and it's in the law too.
Yeah,
it's in the contract and it's in the statute. And that, of course, represents the legislation from last year. Yes. But, might an attorney make the argument, well, it's one thing to get examiners to address the issues about, they're obligated by contract and statute to address matters of commitment in AOT. That being said, the law also says that that kind of information should not be shared in these proceedings based on, pre-existing statute. So I don't know how that's going to play out. And I don't know if anyone has that experience with attorneys making that very claim. Although I guess you had some experience there, Anthony. Yeah. All right.
Right. Yeah. One of the experiences, because the argument was that although we're obligated to write about eligibility in the report, the other language is about admissible testimony. And it says that no testimony from this, information from the competency exam shouldn't be admitted for any purposes other than informing the defendant's competency.
Right.
And so the argument was, if dangerousness is incorporated into our competency exam, does testimony on dangerousness, is that actually connected to competency, or are those actually separate issues? And that's where the language gets very muddy. And I know at one time, somebody that got called, the state was attempting to rectify it by having her talk more generally, the examiner more generally, about dangerousness of a person with the disorder that the person has and the circumstances, without actually commenting on the defendant's specific dangerousness, to try to get around that.
Yeah. Well, there's certainly issues to be addressed. Let's talk about competence to stand trial in New Mexico in terms of more sort of substantive, concrete matters here. What about the constitutional requirement? I've got two preliminary questions. Does the law require that litigants be competent to participate in all legal proceedings or just some? And if your answer is just some, can you identify a kind of legal proceeding that can take place even with an incompetent litigant, a litigant who is incompetent to participate? Or incompetent to stand trial, if you want to use that term. Does the law require that litigants be competent to participate in all legal proceedings or just some legal proceedings? That's a yes, no. And then if yes, if it's just some legal proceedings, can you think of a legal proceeding where the court is more than willing to move forward with an adjudication involving an incompetent person? Anyone want to take that question?
Susan noted guardianship in the chat.
Guardianship, I would also think civil commitment, right? I think they're two good examples: guardianship, conservatorship, and civil commitment, right? Just think about how crazy that would be. This person is so impaired, we can't move forward with a commitment hearing. Okay, so what do you propose we do? I know, why don't we put them in a hospital and treat them so they can become competent to participate in a commitment hearing? That just seems sort of ludicrous at some level, right? So yeah, people are routinely processed in commitment proceedings without having a meaningful understanding of the proceeding because of the very impairment that results in the commitment being sought in the first place, and guardianship proceedings as well. As an aside, Florida has a very detailed guardianship law, and there's 13 rights actually that can be limited by way of guardianship proceedings in the state of Florida. And one of the rights, this sort of at some level is odd. One of the rights that you can lose is the right to sue and be sued in the state of Florida. In that case, if a court determines in a guardianship proceeding that you're incapacitated so that you lose the right to sue and be sued, they put in place a guardian who sues and defends you on your behalf. Obviously, the guardian would do that with the assistance of an attorney. And this only applies, of course, to civil proceedings, but you can actually be adjudicated as lacking the capacity to litigate, in which case the guardian would exercise, would be involved in litigation on your behalf, seeking counsel when necessary, etc. Some constitutional cases here. Why is it that we're not willing to prosecute or move forward with prosecution of incompetent criminal defendants? One is because the Sixth Amendment right to counsel, confront accusers, and due process rights are pretty significant. And one can argue, what's the value of these rights if you're so impaired you can't exercise them? That's one reason to have this requirement in place when it comes to criminal proceedings. I think part and parcel of that, of course, is how significant criminal proceedings are, right? In terms of what's at risk. Someone can receive an extended prison sentence with all the associated limitations of liberty. But one point, you have very important rights as a criminal defendant, including some of these rights laid out here. And how meaningful are these rights if you're so impaired that you can't understand and participate in the proceedings? Another reason for the requirement is to decrease the likelihood of inaccurate and unjust outcomes, particularly wrongful convictions. The thought is that defendants who do have capacity can work with their attorneys to avoid wrongful convictions, not all the time, but certainly if someone is not able to tell the defense attorney about an alibi or work with the attorney to challenge the testimony of adverse witnesses, the likelihood of a wrongful conviction is increased. And then finally, what's been cited as a rationale for the competence requirement is the society's interest in preserving what they call the dignity of the criminal process. I mean, what does it do for how people think about the court system or the criminal justice system if it would be willing to prosecute people who are so impaired that, number one, they can't understand and participate in the proceedings, and maybe don't even have an awareness of the proceedings? It's very much apparent that in order for the court system and the justice system to work, we need people to respect it. I often point out that courts are one of the few places nowadays where there are old school rules about conduct, right? So, for example, you can go into many churches and synagogues nowadays and see people in shorts or flip-flops. You can go into high-end restaurants. You can see people, wearing tennis shoes and shorts and polo shirts. You can go into classrooms and see students wearing their pajama bottoms. But there is one place where there are a lot of rules and requirements, right? You can get thrown out of courtrooms because you wore a tank top. You can get thrown out of courtrooms because you opened up a newspaper. You can get thrown out of courtrooms because your cell phone went out. You get thrown out of courtrooms because you were chewing gum. You can get thrown out of courtrooms because they didn't like how long your pants were or your shorts were, something like that. And what's that all about? That's all about having a dignified setting where people are serious and respectful. And if you don't follow the rules about dress and, reading newspapers and playing Candy Crush on your phone, you can get removed from the courtroom. That's probably best case scenario. You can lose your phone, you can lose your newspaper, or maybe even be hit with contempt of court if your behavior's more problematic. And I think that's all about preserving the dignity of the legal process. So a number of reasons that we have this requirement in place. It's a low bar to consider the issue about competence, right? Pate versus Robinson, another Supreme Court case. Supreme Court says considerations of competence should occur upon demonstration of a bona fide doubt. So if someone holds a bona fide legitimate doubt, just doubt is good enough to trigger the inquiry. And I have here a low bar for good reason. I think the answer is yes, because we don't want to run the risk of wrongful convictions. We want a dignified process. It's important that criminal defendants are able to exercise these important rights. So if there's just a doubt, a bona fide doubt, sure, let's investigate the issue. And we'll see here coming up how there's language specific to New Mexico that is completely in line with this reasoning or bar set in Pate. So here's the case, right? State versus Flores. Whenever a legitimate concern about the presentability of a defendant to consult and understand is brought to the court's attention, the court is required to consider whatever competence-related evidence is before the court and determine whether there exists a reasonable doubt, sort of similar to bona fide doubt, as to the defendant's competence. If the court determines there is reasonable doubt, the court must have the defendant's competence professionally evaluated by a qualified professional who must submit a report to the court. So we have this case here in New Mexico, sort of, I think, maybe embracing the spirit of Pate. Raising the issue in New Mexico, the court or the parties, defense, prosecution, the court can order a mental examination of the defendant before coming to a decision about competence, presumably if a bona fide doubt has been made clear. If the defendant is determined to be indigent, the court shall pay for the cost of the exam from funds available to the court. I don't think that really happens. I think that money comes from elsewhere in the state's budget. If a party makes a motion, that would be the prosecution or the defense, there must be a motion that includes a recitation of a number of factors. Number one, that it's a good faith belief. I would say a bona fide doubt, legitimate belief or concern. A description of the facts and observations that lead to the petition. What is it that the defendant said or did that raised this or brought this doubt to light? And then, as you might expect, language suggesting that the defense counsel need not provide an explanation that risks violating attorney-client privilege. Also, there's got to be an affirmative claim or affirmative acknowledgement that this is not simply a move to delay the proceeding. I'm not prepared, and so I'll just raise the competence issue. I guess a statement as to whether the motion is opposed by opposing counsel, and then this defendant information sheet and the request for the competence evaluation itself. I would point out a couple things here, specifically with respect to this, a description of the facts and observations about the defendant that have formed the basis for the motion. I practiced in Florida for 35 years. Florida had a similar requirement. I never saw that motion. I don't think Florida enforced a similar requirement to New Mexico's. Coming to New Mexico, I've consistently seen these motions, which in many cases are helpful to me as an examiner. What did the defendant say to the defense attorney? What behavior did the defendant exhibit in front of the defense attorney, or maybe in front of the judge and the defense attorney and the prosecutor, that raises the concerns? I think that gives me an advantage as an examiner to know what formed the basis for the referral for examination. I think I can do a better examination of the defendant's competence knowing what it was that facilitated the motion to begin with. Never saw that in the state of Florida when I worked there for 30 years, even though it was required there statutorily as well. Some more case law here. A motion on behalf of an accused for a judicial determination of mental competence to stand trial shall set forth the ground for belief that such mental capacity is lacking. That's consistent with what we just reviewed. When the motion does not set forth grounds for reasonable cause to believe the defendant may be insane or mentally incompetent, we're only concerned ourselves with the competent question here, the motion can be denied. So there's this affirmative obligation of compliance with the statutory requirement. Statute requires an examination only when it shows that there's a reasonable cause to believe that an accused may be presently insane or otherwise mentally incompetent. So presumably, the court could deny the request for the motion for consideration of competence if the petitioning party doesn't comply with the requirements here of New Mexico Rule of Criminal Procedure 5-602. Okay. All right. If the court raises the issue, the court itself is to identify its concerns or the basis for its concerns. In my experience, over 30 some years, almost always the competence issue is raised by the defense. I think that's for a number of reasons, including that it's the defense attorney that has the best understanding of the defendant and his or her functioning. Pretty much all the prosecutor gets to see is the defendant's conduct in the courtroom. Same thing for the judge. The defense attorney should have many more looks and better insight in most cases, I think, into the defendant's functioning, not only because they're there during the defendant's appearance in court, but also during any private one-on-one sessions where the defendant's more likely to be speaking, sharing concerns that maybe raise concerns by defense counsel himself or herself. A lot of times what I saw as I was reviewing New Mexico code and New Mexico rules of criminal procedure was a lot of overlap and repetitiveness, which I've seen that before in other states' codes too. This sort of is ringing consistent with what we already covered with sections drawn from the New Mexico rules of evidence. Court may authorize a district attorney or the Department of Health to use a report of any examination ordered before a determination of a defendant's competence for the purpose of initiating proceedings in accordance with the Mental Health and Developmental Disabilities Code or the Assisted Outpatient Treatment Act, provided that the report remains valid pursuant to the time limits set forth in that code or act. I apologize for that. Let me go to this. Contents of the report. We'll get back to that in a second. Very explicit discussion of what must be in the report. Similar with statutes that I've seen in other states, Utah, Florida, Texas. The report shall include the following: a description of the procedures, tests, and methods used by the evaluator, clear statement of clinical findings, opinions about the defendant's competence, and if the expert opinion is that the defendant is not competent, then the expert shall provide further opinion as to whether the defendant satisfies the criteria for involuntary inpatient civil commitments in accordance with Mental Health Developmental Disabilities Code or involuntary treatment in an AOT program. This obviously represents changes that were made subsequent to legislation that was introduced or passed last year. In addition, the report will include a description of the sources of information and the factual basis for the evaluator's findings and opinions, provided that the report shall not include information or opinions concerning the defendant's mental condition at the time of the alleged offense, or any statements made by the defendant regarding the alleged offense or any other crime, and the report will include the reasoning by which the evaluator used the information to reach the clinical findings and opinions. So, I mean, I really appreciate the legislature's efforts to provide examiners with this degree of detail with respect to what it is that needs to be in the report. That being said, what does it mean to be competent to stand trial in New Mexico and elsewhere? The constitutional minimum was identified by the Supreme Court in the case of Dusky. I think most people in this training are familiar with the Dusky matter. Interesting, shortest Supreme Court opinion I ever saw, 2 pages, the Dusky opinion. The defendant must have sufficient presentability to consult with counsel with a reasonable degree of rational understanding and a rational and factual understanding of the proceedings. That's what's minimally required. I always make the point that a particular state could require that you have a law degree in order to be prosecuted. Now, no state would do that because it makes no sense, but a state could provide more protections for criminal defendants that could not only require this, but could require, some period of legal training or no, I'm not aware of any state that gets anything close to that. But what the Supreme Court has identified here is what's minimally required of a defendant in order to move forward with prosecution: sufficient presentability to consult with counsel with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceedings. A lot of law professors have spent a lot of time analyzing this quoted language. Few points I'll make. You'll notice here, like New Mexico statute, there's no explicit reference to mental disorder rendering someone incompetent. Many states make explicit that in order to be adjudicated incompetent, it has to be due to, they'll use language like mental disorder, mental disease or defect or something like that. Some states which have language regarding juvenile competence will talk about mental disease or defect or, quote, developmental limitations, unquote. But they talk about what ability the defendant must have, but there's no identification about what can render a defendant incompetent in the Dusky decision. Many jurisdictions specifically reference mental disease or defect or some language to that effect. You can carve up the Dusky standard and say there's either 2 prongs or 3 prongs. You could say, well, in order to be competent according to Dusky, you must have ability to consult with lawyer or counsel with a reasonable degree of rational understanding. You must have a rational understanding of the proceedings and a factual understanding, 3-prong test. Or you can make it a 2-prong test. Capacity to consult with counsel with a reasonable degree of rational understanding and a rational factual understanding of the proceedings. I don't know how much of a difference that makes, but there it is. It's clearly present oriented, particularly is distinguished from mental state at the time of the offense evaluations, the focus of which is a defendant's emotional, behavioral, and cognitive functioning at and around the time of the offense. Present oriented and the immediate future, and it's really cognitively focused, not any reference to emotional functioning here, although I think you might be able to shoehorn it in. The language that has been used in Dusky has been cited as suggesting that it's a capacity or ability to engage in these behaviors, maybe as being distinguished from willingness. So you could have maybe someone who's capable of meeting the Dusky test or standard, but is not willing to consult with counsel or not willing to engage in other activities. This reasonable degree of rational understanding, that language has been used has been interpreted by commentators as suggesting that someone's capacity need not be perfect, right? There can be some impairment if they have sufficient present ability, enough present ability to consult with counsel, and a reasonable degree of rational understanding. So the court is not looking for perfection if the defendant can demonstrate enough present ability, as distinguished from willingness, to consult with counsel and a reasonable degree of rational understanding. There can be some chinks in the armor. So we're not looking for perfection here. So that's the constitutional minimum. What does New Mexico state? Many states have adopted the Dusky language verbatim. And New Mexico, you can see the influence of Dusky in New Mexico statute, but New Mexico does not simply repeat the language that the Supreme Court offered in Dusky. Sufficient present ability to consult with lawyer with a reasonable degree of rational understanding. That's about as Dusky as you can get. Rational and factual understanding of the proceedings. That's about as Dusky as you can get. But then what you get is the third factor. The defendant must have the capacity to assist in his own defense and comprehend the reasons for punishment. So that's really the tweak that distinguishes, as I think about it, New Mexico's consideration of competence from what the Supreme Court offered and many states endorsed in the Dusky decision. That being said, I'll point out to those of you who have not practiced outside New Mexico, there are many states that have, while they've adopted as their standard of competence, dusky verbatim, they have one way or the other expanded or provided more guidance for examiners in terms of what they're thinking about in terms of prongs A and B here, in terms of the guidance they provide examiners. For example, in Florida, where I spent much of my time, examiners were required statutorily to identify 6 factors. The standard of competence in Florida, dusky language verbatim, but examiners were required to address 6 factors. Appreciation of charges and allegations, appreciation of possible penalties, appreciation of the adversarial nature of the legal process, capacity to consult and work with counsel, and then finally, capacity to testify relevantly. So one way or the other, various states get there. New Mexico statutes direct that a defendant's competence will be evaluated by a psychologist, psychiatrist, or other qualified professional recognized by the court as an expert. What I'm suggesting is this is sort of an interesting approach to it. They identify 2 disciplines or professions, but then they acknowledge that there are others who could be recognized by the court. But it would appear then that psychologists or psychiatrists sort of automatically qualified. There's also this requirement in state code regarding the report and the report being submitted. Now we're back to rules of criminal procedure. Competence evaluation, examination by, again, a psychologist, psychiatrist, or other qualified professional, recognized as an expert, appointed by and acting on behalf of the court, limited to determining whether the defendant's competence. It shall not state opinions about matters at issue in the criminal case, including the defendant's sanity or ability to form a specific intent. This is some of the language we were talking about, which is, does that preclude at some level consideration about eligibility for commitment, consideration about AOT criteria. And then here is language in statute that again references the recent legislation regarding commitment and regarding assisted outpatient treatment. I acknowledge some of this language appears inconsistent with language elsewhere in statute and rules that make clear efforts to limit how information gathered during the competence evaluation is presented. Here are the criteria for AOT. I'm sorry. Above here are the criteria for commitment. All right. Okay. Now, from here and maybe the next 10 or 15 slides are a lot of procedural. There's a lot of procedure devoted to what happens after the examination is completed. I wanted to provide that. I don't want to discuss it because I think we have a crowded agenda and our time is better devoted to moving on to a discussion of the evaluation process. But I did want to include this recitation of state code regarding what happens after the competence evaluation is carried out. Don't want to discuss it in any detail because sort of weighing and balancing what we should address, I think it's more important that we spend the rest of our time pretty much addressing the evaluation process itself, how we take that information, use it to write reports, and use it to testify. So as we did a little earlier today, I want to zip through a number of these slides and take us to a little quick true-false quiz before we get to a break. And then I turn over the platform to Anthony, who can begin sort of his work talking about the competence evaluation process. So you do have this for reference, but again, I don't think this is the best way to spend our time. So go through this, and we're gonna get to some true-false questions. True or false? New Mexico's competence standard or test is a functional one insofar it is not simply based on clinical factors such as the defendant's diagnosis or need for treatment. True or false? Think about that. I would suggest true is the correct answer given its Dusky-like description of what it means to be competent with that third factor included. New Mexico law explicitly requires a finding of mental illness or intellectual disability for a defendant to be adjudicated incompetent. My answer to that is false. I've not been able to find that. I think there's a presumption that it would require mental illness or intellectual disability, but I don't think there's any language to the effect. I haven't found any language to the effect of, in order to be adjudicated incompetent to proceed or stand trial, one must have a predicate mental illness or intellectual disability. I'm happy to be corrected on that one if I got it wrong. New Mexico law primarily focuses on defendants' capacity to understand and participate in the legal process, as distinguished from their willingness or knowledge about the legal process. I would endorse that with a true. And I acknowledge that sometimes distinguishing between capacity and willingness is a challenge, particularly when there's questions of mental disorder and how that affects someone's ability to make choices and make rational, self-interested decisions. But I explicitly left that for Anthony to discuss in consideration of the assessment process. Examiners appointed by the court to assess a defendant's competence have the option of writing a report summarizing the evaluation and their opinions. I would say false. Statute and rules are explicit. A report must be written by the court-appointed examiner. Matters examiners must address upon recommending defendants be adjudicated incompetent to stand trial include whether they meet commitment and AOT criteria. I would say that's true with the new legislation. Parties seeking that the court appoint an examiner to examine the defendant's competence must submit a motion detailing, among other things, the reasonable basis for their concerns. I would say true. We saw a couple pieces to that effect. And then true or false, examiners' reports must, among other things, detail their reasoning, their data sources, and the assessment techniques they employ. I would suggest the answer to that is true as well. So let's do a case problem or two before we take a break, okay? Ted understands the charges and allegations. Multiple counts of first-degree murder, allegations of bombing and maiming technology experts. He understands the possible consequences, life in prison. He understands how the legal process operates. He understands his rights as a defendant. He says he planted the bombs to communicate how technology harms society. And he says he will take every opportunity to disrupt his trial and make clear how corrupt the system is. he cites his example, he might yell out during the trial. He might refuse to look or address the judge if that comes up. And he also shares he's not even sure he trusts his defense attorney, since after all, he's part of the system. So what are your thoughts about Ted's competence? What are you most concerned about? What questions do you want to ask Ted? And how could the court deal with Ted's stated intent to disrupt the trial? What do you think about this case? You can unmute and talk about it, or could offer some comments by way of the chat. Anyone?
Randy, would you mind please going back one slide just so we have the details to reference?
Yeah,
Thank
yeah,
you.
there you go. This is all he gets. What are your concerns here? And I understand you probably want more information. You probably want more time with Ted. But what are you thinking as this case presents to you with these facts so far? Not asking you to draw an opinion about his competence, but what are your thoughts here so far? What more do you want to know? What more information do you want to gather? Thoughts?
Well, if he's that paranoid and delusional, he's not very rational. And he cannot probably cannot be disabused of those delusional ideas.
Okay. Are you convinced that it's delusional?
I don't think that. I don't think his defense attorney is against him, but we hear that all the time from people like that.
Mm-hmm. Yeah, I don't mean to suggest that his attorney is. I don't have any belief. I'm going to very much assume that his defense attorney is not acting against him.
Right.
I will acknowledge his defense attorney is involved in the system. After all, he might well be a government employee who gets his paycheck for representing indigent defendants. I didn't say he's a public defender, but he might well be part of the legal system. So maybe one of the considerations is this I don't trust my attorney, or I'm not sure I trust my attorney. Is that paranoia, which I think by definition suggests mental disorder, or is it cynicism? Is it flowing out of concerns that are not the product of mental illness? That might be one thing that's worth further consideration, investigation.